My lord, I like to mention three MSc cases which was long pending, my lord. My lord, it can be fixed on 3rd June.
MSc?
Yes, my lord.
Mentioning was really quote number 1. Whether mentioning can be taken by this movie.
Yes.
Huh? Okay.
It's a criminal matter.
3rd June.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 4, Lordship.
Where the cause this one again? Lost.
Sorry.
Vote for this. It's not question to decide. मैं बात करता हूँ, देख लो. Item number
4, Lordship. This may be listed after 2 weeks, Lordship.
is a transfer matter.
Lordship.
You are for the
I'm for the respondent, Lordship.
respondent. Have you informed the other side?
Lordship.
You are the other side. With the consent of the other side, the learned counsel for the respondent wait for an adjournment. How many weeks?
2 weeks, Lordship.
Considering the submission made by learned counsel, matter may be adjourned, with the matter be accordingly listed after 2 weeks, as on a date to be fixed by the list. Okay.
Deputy Lordship.
The interim was day, interim be continued till next date of list. What kind of interim, in fact?
They have filed divorce petition before the district court duty. So I'm seeking transfer of the divorce petition to Tejo because I'm serving there, single lady. Therefore, the proceeding before the
Proceeding is stayed. Okay.
My Lordship, I would like to mention item number 28. Yes. Kindly, Lordship,
Yes,
kindly this matter may be fixed on this 3rd June. That is Wednesday, Your Lordship.
that is the final. Take it on next week otherwise, because there may be some other matter also. But it's
Normally, Lordship, 3rd June is Wednesday and it is a single bench day, Lordship.
okay. Then. 3rd June you want?
Yes.
At the request made and learned counsel for the appellant, but this the matter on 3rd June. Okay, we'll listing it on 3rd June.
My Lordship, I will mention item number 19. Here, petitioner have to file additional affidavit, but petitioner couldn't come to the swearing, so we will be given 1 week time to file the additional affidavit.
You want to file an additional affidavit here?
Yes, we have to file settlement agreement here. So settlement agreement is ready, but the petitioner couldn't come to swear in the affidavit.
No, at the time of filing the petition, there was no settlement agreement.
There was, but we couldn't file that, so we are filing.
Your MS?
As Somo.
Hard MS as Somo, the learned counsel for the petitioner, and submitted that matter may be adjourned today, as they're going to file an additional affidavit to bring the settlement agreement in the record. Prayer allowed?
Interim may be continued.
Pardon?
Interim may be continued. Interim is there.
Prayer allowed? The matter be accordingly listed. 1 week will do?
Yes, you
1 week as on the date to feel by the registry. Interim be continued till next.
Very good. And I beg to mention item number 7, Your Honor.
Item number
7.
7.
Yes, Your Honor. This matter may be listed after 1 week, Your Honor.
Have you informed the other side also?
Yes, Your Honor, he's present.
You're present? You're for the petitioner?
Yes, Your Honor.
With the consent of the other side, the learned counsel for Baki indicated pursuant to pay final adjourn. Prayer allowed? 1 week will do, or
1 week, Your Honor.
1 week?
Yes, Your Honor.
So matter after 1 week as on a date to fixed by the registry. Okay.
With purpose.
Oh, may I, Your Lordship? Your Lordship, I'm mentioning item number 26. I'm for the respondent here. With due consent from the other side, kindly this matter may be listed after 3 weeks.
3 weeks?
Yes.
The MSc appeal is of 2023 and most probably the judgment of the MSc court was of which year?
It was of year
2023, sir.
22. 23 years.
So you are for the appellant.
I am for the appellant. My lord, fixed date is recorded.
Want to fix it?
Thereafter.
With the consent of the other side, the learned counsel for the respondent paid for an adjournment. Yes, after 3 weeks and dates also.
18th of June, Lordship.
18th of June will be
After 3 weeks.
18, my lord, 18, I am preoccupied. 19, it's the.
19 is Friday,
Oh. Then 21.
22, Lordship.
22.
Oh, Monday, Lordship.
Monday.
Please, my lord. My lord, I'd like to mention item number 16, my lord.
Item number 16.
16, my lord. My lord, here, earlier, my lord, stay was granted, my lord. Thereafter, my lord, the matter was sent to the mediation, my lord. And thereafter, my lord, the next day fixed, my lord, since the matter could not be solved in the mediation, my lord, the stay was, vacated, my lord. And now it has been heard that they have filed the charge sheet, my lord. But in fact, earlier when I filed this application, my lord, the charge sheet was not filed, my lord. Therefore, my lord, I will be granted 4 weeks time, my lord, to challenge the charge sheet, my lord. It is a quashing application, my lord.
No, but there was no stay of for investigation. I think that's why.
No,
Sure.
but later on it was order dated 06/2025, my lord. It was vacated, my lord. And the prosecution was allowed to file the charge sheet, my lord. So I'm not, I don't have the charge sheet, my lord. Therefore, my lord, since earlier I only prayed for his staying and quashing of the FIR, my lord. Now, since the charge sheet has been filed, I may be
You
allowed
have
to.
to, yes.
Therefore, my lord.
Have you informed the respondent side
So,
also?
my lord, the PP is here, my lord.
PP is there.
Charge sheet.
Okay. Mr. Upadhyay.
And-
Hey, Okay. Heard Mr. Upadhyay, learned counsel for the petitioner, and also heard your, what was the name? Sir, sorry.
Deloy.
D. Lolen.
Deloy.
D. Loy.
Deloy.
D. Loy. The learned additional PP appearing. Your PP, na? PP appearing for the respondent. It's submitted by Mr. Upadhyay that he needs 4 weeks time.
My lord, my lord.
4 weeks time to challenge the, or to also challenge the charge sheet as the case has already been charge sheeted during dependency of the present petition. In view of this, prayer allowed, let the matter be accordingly listed after 4 weeks as on the date to be by the ministry. Okay.
All right.
May I also? Lordship, I beg to mention item number 6. On, yeah, Lordship. Lordship, I'm appearing behalf of T. Tucker. Kindly this matter may be fixed on 15 June.
You are for the appellant.
Yes, Lordship.
Respondent side is not appearing here.
Not appearing.
You are appearing for
T. Tucker on behalf of T. Tucker.
TTAC. You are Mr.
B. Sibo.
Heard Mr. B. Shiva appearing on behalf of Mr. T. Taki, the learned counsel and his counsel for the appellant, accordingly paid for an adjournment, stating that he is, due to inconvenience, he is not in a position to argue the matter. Prayer allowed, Mr. Matter up on 15th of June.
15 of June. Lordship, and another matter, item number 15.
1-5.
Orders matters. As for order dated, office note dated 30/5/2026, TCR has not received, and respondent number 1 is not yet to file wakalatnama till now. So kindly this matter will be listed after 4 weeks.
Mr. T. Sobo, the learned counsel appearing. Here also you are appearing for Mr. T. Tapak or
Yeah, T Tabak.
T. Tapak? And submitted that the TCR and the service on the respondent is still awaited.
Lordship, service is completed, but not filing wakalatnama.
TCR is still awaited, Bakihin Lipa. Further, he submitted the service is completed, but the respondent is yet to file his wakalatnama. In view of this, matter will be listed after 3 weeks, after 3 weeks as on a date to effect by the weeks.
Bless ma'am.
Item number 1,
Yeah, please.
Yes, Mr. Sonu.
My lord. So this is civil revision petition, my lord, under Article 227 of the Constitution of India, my lord. Here, my lord, I have a very simple prayer, my lord, especially my lord, seeking direction to the, my lord, this apex customary court, Dari Circle, to consider and dispose my lord, pending appeal petition dated 13/4/2026, which they have orally refused to consider this appeal, my lord. Now, my lord, this apex customary court, my lord, this is a court, my lord, it is a statutory court recognized on both under the, my lord, Assam Frontier Administrative Regulation Act as well as the Arunachal Pradesh Civil Courts Act, my lord. Now, my lord, they are incumbent, my lord, whenever there is an appeal against the Kebang village, Kebang decision, my lord, they have to consider, my lord, whether they allow the appeal, whether they dismiss the appeal, that is a different issue altogether, my lord. But they have to consider whenever there is an appeal, my lord. So in the present case, my lord, the appeal petition which I have annexed in annex number 10, my lord, is filed on 13/4/2026, my lord. Of course, my lord, this is a, my lord, here what happened, my lord, this has a very checkered history, my lord, of this particular case, my lord. What happened here, my lord, just give some brief facts of the case, exactly, my lord, what happened, my lord. My lord, ordered the Kebang decision dated 17/12/2011, my lord. Decision, my lord, Kebang decision dated 17/12/2011, my lord, that the Kebang held that the land in issue, the disputed land belongs to the petitioner. But the Kebang decided that, okay, allow the respondent to stay there temporarily, my lord. So no permanent structure should be constructed, my lord. So on humanitarian ground, that was allowed, my lord. Later on, my lord, when it was found that the respondent, my lord, violated this Kebang decision, therefore, my lord, the petitioner filed the appeal before the before the CO, circle officer, my lord, because, my lord, earlier Assam Frontier Regulation, my lord, unamended, my lord, the appellate authority was the circle officer, my lord, extra assistant commissioner, deputy commissioner, my lord. But what happened, my lord, the circle officer, my lord, instead of deciding the matter himself, he endorsed the matter to the Bango level Kebang, my lord. Now here, my lord, one point is very important, my lord. At that point of time, my lord, when this matter, this in 2012, when matter was referred to Bango level, my lord, at that point of time, this Bango level did not have that recognition, statutory recognition, as now we have today, my lord, because post amendment of the Act in 2021, after enactment of this Arunachal Pradesh Civil Court Act, my lord, now apex customary court is recognized, my lord. Earlier, this Bango level Kebang was not recognized, my lord. There are series of judgment on that point also, my lord. And what happened, my lord? And that Bango level decision also, my lord, although said affirmed the decision that the land belonged to the petitioner, again the Bango level failed to give the possession of the land to the petitioner. So, my lord, against that Bango level Kebang decision, appeal was filed to the additional deputy commissioner. At the time, additional deputy commissioner was the appellate authority. Here again, my lord, what the additional deputy commissioner did, my lord, he affirmed the decision of the Bango level. Then, my lord, the petitioner had to approach this honorable court by way of filing civil revision petition. And in the civil revision petition, this honorable court set aside the order passed by the additional deputy commissioner and directed the petitioner to file the appeal against the Kebang decision, Bango level Kebang decision. And that appeal was filed before the additional deputy commissioner. So, my lord, during the pendency of this appeal, what happened that there was a change in the law, and this executive of these officials, my lord, those were the deputy commissioner, EAC, my lord, judicial power, my lord, their judicial power have been scrapped, my lord. Thereafter, my lord, the appeal thereafter lies to the, my lord, additional district judge or civil judge, senior division, junior division, my lord. Accordingly, my lord, that appeal was transferred to the additional district judge, Basar, my lord. And additional district judge Basar, my lord, set aside and quashed the Bango level decision, my lord. Bango level decision that was passed on, my lord, 6/2/2018. That decision was passed on the ground that Bango level did not have jurisdiction at that point of time when the decision was given, because at that point of time, my lord, there was no amendment. So only the village level Kebang authority, but Bango level did not have authority. So therefore, that Bango level decision has been set aside and quashed by the additional district judge, Basar. Now, what happened, my lord, while quashing the Bango level decision, what happened, my lord, is still that village level Kebang decision of 2011, it has remained, my lord, unaffected. And that remained unaffected, my lord, and still it remained operative, despite, my lord, I have been pursuing the matter since 2012, my lord, against this particular decision, my lord. So therefore, my lord, now, my lord, post amendment of the law, my lord, now the Apex Customary Court is the appropriate authority, competent authority where the appeal lies, my lord. Accordingly, my lord, I filed the appeal, my lord. But the appeal has not been considered and not passed any order. Verbally said that will not consider, my lord. So therefore, my lord, since customary court is a court, my lord, it is amenable to the jurisdiction of this honorable court under Article 227, my lord. So my prayer at this stage only, my lord, direction to consider and dispose my appeal, my lord. Whether it is in my favor, it is in his favor, my lord, that is not the issue at all. So, my lord, this my humble prayer, my lord, this petition can be disposed at the motion stage itself, my lord. Just directing that to consider, which is my lord, annexure 10 is my appeal, my lord. My lord will find at page number 55.
Apex, what do you call it? It is Apex Customary Court.
My lord, my lord.
Apex Customary Court against the which you are in now. You're challenging the which order now?
My lord, kindly
Because there
page
are
number
many matters are there. Many you have submitted.
My lord.
Many events were there wherein several orders by this court is also been set aside. One CRP is
Yes.
also there. Then the
Yes.
additional DC also set aside one order, then transferred to
My
Bango
lord.
level committee. These are things are there. So
My
now
lord,
you are put challenge which order now?
My lord, kindly turn to page number 55, my lord. Page number 55, my lord. My appeal, my lord.
Yes. Yes.
Appeal against the Kebang decision.
review
Yes, my lord.
that was taken
Kebang
on 17/12.
17/12/2011, my lord. My lord, as I have submitted, my lord, this 17/12/2011, since 2012, I've been challenging this decision. And I challenged before the right forum, before the assistant commissioner, circle officer. But the circle officer, instead of deciding himself, he referred the matter to the Bango level. It was not existing at that point of time. In that view, matter remained pending for a long time. I approached this honorable court, and finally, my lord, Bango level decision has been set aside by the additional district judge. But this judgment has remained intact, my lord. This impugned judgment. So, on the basis of this village level Kebang decision, now the respondent is trying to make the permanent structure. That's why I have filed the appeal, my lord. Now, my lord, Apex Customary Code post amendment, my lord, has the authority, my lord, and jurisdiction, my lord. So it is, my lord, whether to consider or not consider, that is on merit, that is will be a different question. But as to consider whether they don't want to entertain, whether they don't want to do anything, at least, my lord, some order has to be passed. Thereafter, I can, but they cannot just receive and they cannot just sit
But
over
they
the-
have already, oral order was there because as it is not maintainable, or what kind of order? Yes, submitted
lord-
that one oral, though there was no written order, but then
My
oral
lord,
order was
so,
also
my
there.
lord, at least, my lord, formally it has to be disposed, my lord. Just informally saying I will not, that is not enough. At least, my lord, so that I can take the further legal course of action against if they refuse, my lord. So now, my lord, it's not, neither they are doing anything, at least formally, either they refuse or either some grounds would be there, my lord, why they are not entertaining this appeal, my lord. So this is where, my lord, they are, my lord, not exercising their power, my lord. The statutory power which is conferred on them, my lord, that has to be. That's why, my lord, this civil revision, just to consider this pending application at this stage.
Heard Mr. Arsona, the learned counsel for the petitioner. This civil revision petition is filed under Article 227 of the Constitution of India, seeking direction to the Apex Customary Court, the Recircle, Leo Leparda District, Arunachal Pradesh, to take up and to decide the appeal petition dated 13/04/2026 filed by the petitioner against the village level Kebang decision dated 17/12/2011. Next point, it is submitted by Mr. Sonar that there was the disputed land. No, there was a dispute over the land, and the petitioner's complaint was initially filed before the village level Kebang, and on 17/12/2011, it was held that the petitioner has the ownership, but directed the respondent to temporarily reside over the disputed land, and with further direction not to construct any permanent constructions over the disputed land. But subsequently, the respondent had violated the order of the state, or violated the Kebang decision, and for which a petition was moved before the circle officer, and subsequently the circle officer had wrongly referred the matter to Bango level BAN GO, Bango level Kebang, which was not at all a competent appellate authority under Assam Frontier Administration of Justice Regulation 1945. Full stop. However, the said Bango level decision Bango Kebang had confirmed the ownership but failed to direct for any ejectment, and thereafter a petition was moved, and who moved before ADC Basar? You
my lord,
filed
this
the petition.
my lord, petitioner, my lord.
The petitioner then filed a petition before the additional Deputy Commissioner Basar, but the additional Deputy Commissioner, but thereafter you have filed one CRP also, no?
Yeah, my lord, because additional
When
deputy commissioner,
White order dated 10/8/2018, additional deputy upheld the Kebang decision. Thereafter, CRPC was filed, my lord. My lord will find at Annexure 7, my lord, the order of pass in CRP, my lord.
Annexure?
Annexure, my lord, 7, page number 31, my lord. My lord, operative portion, my lord, page number 35, my lord, will get. 35, my lord.
Yes. So by that CRP order, your delay was condoned for
Uh,
preferring
the-
appeal.
My lord, that was condoned, my lord, and directed that that appeal has to be filed before the deputy commissioner, who has to consider, my lord, additional deputy commissioner. Then that was done, my lord. Then post amendment, that appeal was transferred to the, my lord, additional district judge, Basar, my lord. And the additional district judge has set aside and was Bango, my lord. But that village level has remained as it is, my lord. That's why.
Would you like a little appeal? And in addition, the commissioner had upheld the order of the the Bango Kebang, and thereafter, and CRP was filed before this court, wherein by condoning the delay, the parties were asked to approach the appropriate forum of oblique the deputy commissioner. As per the in pursuant to this order, the petitioner accordingly filed an appeal before the additional deputy commissioner and deputy commissioner, but during this but for the ADC thereafter as after the amendment of the civil law, Arunachal civil law, Civil Code law.
Civil Codes Act.
On the Civil Code Act, the additional deputy commissioner had transferred the matter to the additional district judge, Basar. Before the additional district judge Basar, the matter was heard, and the additional district judge Basar, by its order dated 17/9/2025, had paused the decision of Bango Kebang for want of jurisdiction, but did not make any order in respect of the impugned decision filed by the Kebang dated 17/12/2011. Thereafter, the petitioner had moved. Thereafter, the respondent tried to encroach the disputed land and also trying to construct the permanent constructions over the disputed land. And in that purpose, they have also gathered some construction materials. In view of this, the petitioner again preferred an appeal before the appropriate forum, that is the Apex Customary Court, the recircle, on 13/04/2026, which was accordingly received and acknowledged, but without any assigning any reason, there was no order is passed in the said appeal which was filed before the Apex Customary Court, full stop. He further submitted that as per the amended section of Section 5 of Assam Frontier Administration of Justice Regulation, Amendment Act of 2023, the customary Apex Court has the jurisdiction for entertaining the appeal against a Kapang decision, but without passing any order, the said appeal is still lying before the Apex Customary Court. Full stop. In view of this, by the present civil revision petition, it is paid by the petitioner for a direction to the Apex Customary Court to dispose of the appeal petition dated 13/4/2026, which was preferred by the petitioner against the impugned village level Kebang decision dated 17/12/2011, which is still in existence. It is submitted by Mr. Sonar that the that though the petition, though the appeal was filed on on 13/4/2026, but till date there is no order in written passed by the appellate authority, that is the Apex Customary Court, and hence the petitioner is also not in a position to approach any other appropriate forum if appropriate forum full stop. In view of this and considering all the aspects of the case, the present civil revision petition is disposed of at the motion stage itself with a direction to the Apex Customary Court to dispose of the appeal petition which is pending before the court and which was filed on 13/4/2026 within a reasonable period, preferably within 2 months will do. Within 2 months, within
Right.
2 months. With the above observation, the present motion disposed. Okay,
Deeply over.
it is disposed.
My lord, deeply.
Item number 2. Yes.
Lordship, due to some emergency, the leading counsel has left the court. This matter may be listed tomorrow, Lordship.
Tomorrow evening? Tomorrow DBS, there are some matters are already been fixed, so let it be on Wednesday. Oh, okay.
Okay.
But otherwise also Lordship, here some non-compliance of the Lordship, mandatory provision Lordship, non-compliance of notification 17 Lordship. Since section pertain to this FOCSO Lordship, here the applicant not made the victim as a party.
Oh, why? Victim is a POCSO.
Yes,
Yes,
Lordship.
Oh, then why victim is not there?
His mother is the complainant, Lordship.
Huh?
So we have made the party.
So Srimati XYZ, who is she? She is the informant complainant.
And she is the complainant, Lordship.
So mother is already there?
No, not made party. Any matlab Lordship, support person Lordship. The mother victim was not made party and neither the mother Lordship, the informant.
See, they're saying that she's mother? XYZ is mother or who?
As per the notification, mother or informant has to be made the party Lordship. As per
So
the
who is XYZ? She's mother.
Yes, Lordship.
They are saying she's mother?
Lordship,
Is there any bar for disclosing the name of the
Uh,
informant also?
Lordship, difficulty is in my Lordship, in my
Oh,
it was not
Yes.
yet Lordship.
What?
That's why.
I think this the filing section has already furnished the copy before filing this matter. I think that must be the
before
issue.
the filing matter, copy furnished probably for.
I will furnish a new service copy to the PPC by today itself.
Why there are two copy?
No,
One with versus so and so,
Yeah.
one with, it's not.
there was while filing there has been a mistake. There has been an error by not putting the opposition party to number
Ah.
2. So we recorrected it and served the copy.
In that case, Lordship, I have no reason since they met party to the
No,
information.
you should get the proper copy then.
Yes, yes. He may
Should
be
we
not-
pass any order today? Because notice is to go.
Yes, Lordship.
Okay, notice.
Yes, Lordship.
In that case, it will be not put up on Monday, I mean Wednesday. By issuing notice for the respondent number 2,
Yes.
or you want to submit anything?
No, Lordship.
So what I'm saying, no need to make any submission today
Yes, Lordship.
because engaged counsel is not there. As because it's a case of POCSO related to POCSO Act, so notice has to go
Yes.
to the respondent number 2, that is the informant, maybe mother or whoever.
Yes.
So let us issue notice. In
Yes.
that case, it may not be fixed on Wednesday. We at least 1 week time will be required.
Yes,
She's from which place? She's from which place?
This
From
Sur village.
Lordship.
Sur village.
Yes.
Yeah, within Naharlagur.
Naharlagun
Yes,
itself. So through PP office only, it will
Yeah,
go?
Lordship. Rotate through the office.
Yes, yes. You are Mr.
Kegao.
Heard Mr. K. Gao, the learned counsel for the petitioner, also heard Mr. Deloy, the learned PP, appearing for the state respondent number 1. The issue notice to the respondent number 2 through jurisdictional police station routed to the office of the routed to the office of the registry and the public prosecutor. The steps will be taken within 2 to 3 days to the respondent number 2. However, no formal notice is required to be served on the state respondent number 1. Also call for the, we can call for the case diary also.
Yes, Lordship.
We will call for the case diary. Further, it is submitted by Mr. Considering the submission made by Mr. Rohi, the learned PP, it is seen that the proper copy is not served to the state respondent number 1. In view of this, the petitioner is hereby directed to serve a proper copy to the respondent number 1 during the course of the day. During the course of the day. This is the matter. After 1 week, the dates up.
8 Lordship next Monday.
8 of June,
Okay.
next Monday.
Next month.
So you serve a copy, proper
Yeah.
copy to
Just
the
receive the corrected one.
Okay then. Okay.
Item number 3.
Yes.
Terms of the order dated 19/5/2026. The applicant has already appeared before the IO.
But there was any interim was there?
Yes.
Okay.
The Lordship, my object is that I'll be appear before the concerned IO as and when he will be called for. So
No, it is not made absolute, I think.
no, no.
Yeah.
Therefore, I'm praying for the absent.
No, you have
Yes,
received.
yes, we received CD, Lordship.
CD you have received.
We received CD, Lordship. CD
Okay.
received, Lordship.
So
Uh,
submit what you want to submit.
Lordship, since his applicant statement was recorded, Lordship.
Statement is not yet recorded.
Recorded, Lordship.
Recorded.
Recorded and bail bond amount was also, Lordship, deposited. Lordship.
What is the case about?
Case is
318.
allegation of Lordship preparing Lordship fake LPC, Lordship. But as per my understanding, Lordship, when LPC was issued, there are certain procedure which have to be followed, Lordship. But like Lordship, no objection from all adjoining Lordship boundaries, Lordship, AGB and any Lordship GPC signature, Lordship, NOC from all the concerned Lordship is required, Lordship. I think in this case, here the Mandal is discharging his official duties, Lordship.
Lordship, the allegation which has been alleged against me, the complainant is the wife of a husband who has gifted the land in favor of the other 2 accused person. In this case, the husband was present and all other persons were present. My case is only that, Your Lordship, whatever I have done was in all official capacity, in presence of all the witnesses, Your Lordship. I have not committed any error.
You are working as a what strength?
Mandal.
Oh, Mandal.
Yes.
Mandal is very dangerous. Yes.
My-
Hmm.
And Your Lordship, I have given my statement 2 times earlier also.
Before registration.
Yes, yeah, before registration of this instant apart. Your Lordship, I will appear before the concerned IO as and when called for it. The allegation made by the complainant is baseless because her husband herself has gifted the land to other accused person. If she has any grievances, she ought to have lord FIR against her husband, Your Lordship. Not me, Your Lordship.
So you are the FIR accused?
Yes, yes, I'm there.
Other accused persons gifted the land.
3 accused persons.
Lordship, CD, I flag mark the Lordship statement of the accused Lordship, the applicant Lordship.
Regarding ownership, there is no dispute, I think.
Yes,
Her husband was the owner.
yes, yes, Lordship.
Ownership is not.
He only prepared the Lordship land possession certificate.
Based on that, give it, Your Honor. Now, if she has any objection with regard to that ownership, she may file appropriate suit or complaint against her husband only, Your Honor, not me, Your Honor.
You are Mr. Ibam, sorry. Heard Mr. Ibam, the learned counsel for the petitioner, also heard Mr. Deloy, the learned PP appearing for the state respondent. The CD has already been received. This is an application under section so-and-so in connection with so-and-so. CD receipt, where is the same? Next price submitted by Mr. Bum that after obtaining the order of interim pre-arrest bill dated 19/5/2026, he accordingly appeared before the IO, cooperated in the investigation, and his statement is also recorded by the police officer, investigating officer. He further submitted that prior to his statement recorded before the investigating officer, he appeared in 2 occasions before the police station and had cooperated in the investigation of this case. Full stop. Next para, Mr. Baum further submitted that the present accused petitioner is no way connected with the alleged offense, and he had issued the land possession certificate only on the basis of the only on the presence of the witnesses and the owner of the land, and as per his official capacity. That apart, he has not committed any such offense as alleged in the FIR. It is the husband of the informant who gifted the land in the name of other 2 accused persons, and everything was done under the official procedure in presence of witnesses. However, he is still ready and willing to extend his cooperation in further investigation of this case if he is provided with the privilege of pre-arrest bail. Mr. Lloyd, the learned PP, submitted in this regard that the present petitioner had already appeared before the IO and cooperated in the investigation of this case. He also submitted there is no dispute in regards to ownership of the land. However, and further from the CD also it reveals that as per his statement, he issued the land possession certificate only in presence of the witnesses and by complying with all official procedure. Next para, considering this submission made by learning counsel for both sides, materials in the case diary, and also considering the cooperation extended by the petitioner, this court is of opinion that custodial interrogation may not be required for the purpose of investigation.
Lordship, Sorry for interrupting. Small correction, Lordship. He was not the issuing authority, Lordship. Issuing authority is the Lordship Deputy Commissioner, Lordship. He just prepared the
Oh,
Lordship.
sorry. Accordingly, Mr. Lawyer further submitted that the present petitioner is not also the issuing authority. He only prepared the certificate as per official procedure in presence of witnesses. Said Likidaba, line to forward. So and so corridor in view of this, the order of interim pre-arrest dated 19/5/2026 is hereby made absolute with same terms and conditions.
Item number 5.
Your Lordship, the conducting counsel of the respondent, learned senior counsel, is engaged actually on his legs in court number 2. So a short pass over maybe. Oblige, my Lordship.
Item number 8.
Joint petition filed by the victim, informant, and accused for questioning of FIR and charge sheet against them.
For quashing FIR and the charge sheet.
Yes.
Yes, 117,
Yes, sir.
115 and 11735 now. Only informant is there or victim is also there?
No, all informant, victim, and accused.
That's what I'm asking. Victim is also here.
Yes, joint petition.
Petitioner number 1 is the accused number 1. Petitioner number 2 is the accused number 2.
Yes.
3 is the accused number 3 and 4.
4 is
4 is the victim, 5 is the
5
victim,
is victim, and 6 is informant.
6 is the informant.
Mother of the applicant number 4.
Acha. And is there any compromise deed, etc., but also executed, or there's no such?
This compromise deed I file as an additional affidavit at page 75. Additional. A meeting was held at the residence of such and such, contact such and such, to discuss the physical assault of Sri such and such White Nalagan PS such and such by family member of such and such and 3 other accused, namely such and such. After prolonged discussion, the House President finally come to following point and accept by the board party with clear concern. That parent of the accused has voluntarily accepted to bear all the medical expense incurred during the treatment of the victim, namely such and such, and send an attendant to assist them during whole treatment whenever necessary. That such and such victim complaint has accepted to extend all the possible help for withdrawing the case under Nahalagan PS such and such before court of law. That mutual agreement has arrived in view of the fact that Dugi family, Romin family, and Yapa family are relatives, and accused Sri such and such are college students, and the teacher shall not be prejudiced. So under this terms and condition, this settlement has been done. This accused has been charged under 2 sections. 115, that is
Simple heart.
yes, 115 is this is componable. 117(2) is not componable. So, but as per this under 117 BNS, there are 3 categories of punishment. 117 subsection 2, 7 years, that is componable, available. 17(3) is the present case, which is 10 years up to life imprisonment, which is not componable. But to charge the accused under 173, there must be, the injury must be of permanent character permanent disable and vegetative state of the injuries. So these injuries were not found in the chart settlement. Madam, may kindly come to page 43. This is the MLC report of one of the victims. There's two victims here. Here, nature of injury sustained is only simple.
No. 43 you're saying?
Yes, 43 is for the,
It's grievous.
yes, it is grievous, but under section, to attract section 117 subsection 3, the injury must be permanent disability. Here only they have, as per this MLC, suggestive for
Nasal bone
nasal
fracture
bone
was there.
fracture. This is not, permanent disability. This has already been, the victim has already been recovered. And there's no any report of vegetative state.
For nasal bone fracture, if there is any disfiguration, I mean, not disfiguration.
Just
this-
bone has been fractured, nasal bone has been fractured.
Okay, anyway.
It is a grievous injury, but not permanent disability. So, though opens are non-compoundable, but as per this MLC report, this injury come under subsection 2, which is compoundable, 117 subsection 2. And
So
moreover,
he is charged with, charge sheet is filed under 1172 or 1173?
1173,
3.
yes. But as per this report, it should be charged under 1172, which is
You
compoundable.
are saying that it is not.
Yeah.
Oh.
Furthermore, this, two of these alleged accused, they are college going students, so they are relatives. So in view of their future, they have settled this matter. So are studying in Shillong. So I'm praying for questioning of this FIR as well as charge.
Yes, my lord, if my brother's submission is taken into consideration, then my lord, his application will not be maintainable because the offense will become compoundable. So the remedy is there before the trial court. He has to go for the framing of charge and then it can be compounded. Now they are straightly coming before this court, relying on the settlement. So my lord, without going into the merit of the case, the court can rely, basing on the settlement, this matter can be, my lord, interfered with, my lord. Otherwise, my lord, if that clarification has been given to that extent, then my lord, this matter will no longer be maintainable, my lord. Because no doubt, my lord, the section 2 is attracted because there is no any permanent, my lord, vegetative. But when, my lord, this clarification is been given, then all the offense will become compoundable, my lord. So then there is no any ground for exercising the exceptional exceptional, my lord, the
So
power of
better
inherent
not
power
to-
of this court.
Better not to go for 1173 or 1172.
Yes, my lord. Then, my lord, so far as the settlement is concerned, my lord, we don't have any objection, my lord, for the better future of the accused person because there is no any criminal antecedent of the accused persons. But my lord, not on that extent that my lord, regarding the, my lord, at this stage, regarding, my lord, the ingredient of subsection 2, my lord. Because, my lord, even in the grievous injury, my lord, the Supreme Court has held that, my lord, it can be quashed considering the fact and circumstances of the cases. So, my lord, this can be interfered, my lord.
Item number 8. Riba, na? K?
Dabi.
Acha. I heard Mr. K. Dabi, the learned counsel for the petitioner, and also heard Mr. T. Atif, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so for they assess alone at 28 for setting aside and quashing of the FIR dated 14/7/2025, which has been registered as Naharlagun PS case number 93/2025 under section 1173/35 of BNS against the petitioner number 1 and 1, 2, and 3, and charge sheet has also been filed. Charge sheet is also filed dated 21/07/2025 under section 1173, 1152, 35, of BNS. Next para, it is submitted by the learned counsel for the petitioner, Mr. Dabi, that the present the joint petition has been filed for quashing of the FIR as well as the charge sheet, which has been filed against the petitioner number 1, 2, and 3, that is the accused number 1, 2, and 3 respectively, and the accused number 4, 5, and 5 are the victims, who victims, and the accused number, so petitioner number 6 is the informant of this case. First off, he submitted that during the pendency of, after filing of the charge sheet, there was an amicable settlement between the parties, and in view of this, they have also agreed, entered into a mutual agreement whereby the matter has been settled between the parties. It is further submitted that as per the mutual agreement, they have also bear all the expenses for treatment of the victims and the subsequently the matter is also compromised between them. Further, it is submitted that 2 accused persons are also the college going students, and they don't have college going students, and due to some misunderstanding, the incident had happened, but now they are living peacefully without any grievances against each other. He further submitted that on the basis of the mutual agreement, the matter may be in mutual agreement, the present petitioner may, the FIR and the charge sheet may be quashed by invoking power under section 528 BNSS. And he further submitted that even if the matter is allowed to be continued, there is a chance of conviction is very bleak and remote. Rather, it will be an abuse of process of the court. Next para, Mr. Ete, the learned additional PP submitted in this regard, that considering the tender age of the accused persons and other aspects of the case, including the compromise between the parties, the state respondent has no objection in quashing the FIR as well as the charge sheet of this case. Further, he submitted that they have found no criminal antecedents of the accused petitioners, and considering this aspect, the state raised no objection to that regard. Next para, considering the submission made by learned counsel for both sides, and it is seen that the matter has already been compromised between the parties, and in that event, there is less chance of conviction even if the case is allowed to be continued, as there is less possibility to depose against the accused petitioners by the informant as well as the victims of this case. Further, in view of above and also considering the view expressed by the Apex Court in case of Bhajan Lal, this court is of opinion that it is a fit case wherein the petition, wherein the case, wherein the FIR as well as the charge sheet registered against the present accused petitioner number 1, 2, and 3 can be set aside and quashed by invoking the extraordinary power under section 528 BNSS. Okay.
Yes, obliged, ma'am.
Item number 5, passover matter.
You're appealing for whom now?
For petitioner, Your Lordship. My lord, this matter has become infructuous, Your Lordship.
Infructuous?
Yes, Your Lordship.
Achha. Earlier, what was the prayer?
It was, we challenged the order passed by the district court, Khonsa, Your Lordship, where the petitioner was restrained from using the word
it pertained to a celebration, Your Lordship. Local community, they had a celebration. And it pertained
So
to
now the case was pending before which court?
before this court, Your Lordship.
No, CRP
Oh,
is there.
Yes, Your
Otherwise,
Lordship. It was pending before the district and sessions court, district court, Khonsa, Your Lordship.
District Court Khonsa.
Yes, Your Lordship.
So it is settled there, or what do you want to submit?
No, Your Lordship, we filed an appeal against the interim order passed by the Khonsa, district court, Khonsa.
Acha.
Yes. And wherein the district court has restrained us from using the word Golden Jubilee, Your Lordship. It pertains to celebration. That is, now it has become infractuous.
It has already become infractuous. So this petition was moved against one interim order.
Yes, Your Lordship.
Okay, your MS?
D. Tamuk, Your Lordship.
D?
Tamuk.
No, but you are for the respondent.
No, Your Lordship, we are for the.
হয় নেকি?
Respondent.
You are for the respondent.
Oh, I'm so sorry, Your Lordship. Yes.
So even if suppose it may become infractious, but where is Mr. R. Saikia and Titaba is also there.
May I please, Your Lordship?
Yeah.
Your Lordship, in this matter, my senior Mr. Arsakia is not there, Your Lordship. Mr. Teto Taba is the conducting counsel in this matter, Your Lordship.
Then, yes, what do you want to submit?
My
No.
senior's name may be struck. My senior's name may be struck. Struck out from.
Rintu Saikia.
Yes, Your Lordship. He is not
No,
there.
no, his name may be stuck up. No, but what Ms. Diana is submitting, that it has already become infractious. But they are the respondent. That's what I'm submitting.
Yes, he is for the respondent and Mr. Titaba for the petitioner in this case.
If you can inform Mr. Taba, then we can dispose of the matter by today itself. You just try it,
Yes, Lord.
because he is saying that Mr. Saikia is not there in this case.
Yes, Lord.
So his Taba can be informed that you just inform us, we can dispose it. But from considering your submission, we cannot dispose of, that's why.
Item number 9.
May it please, Your Lordship.
দিব আপুনি এই অৱস্থাটোৱে সেইটো হ'ব একো নাই আমি দিছো মনত অলপ কনফিউজন হৈ গৈছিলে তাৰমানে
Well, this is a petition. Under section 528.
কৰিব কি কৰিব
But in fact, I wanted to address your lordship by physically appearing before your lordship. But some matters have been fixed today before the principal bench. I could not come.
I don't know if the problem is from this Arunachal or you are from Guwahati, you're saying?
It is from their side, Lordship.
Oh, it's from your side, it is, we are facing some problem. We could not hear you properly. No, it's a echo sound is there, in fact.
Maybe
So
somebody.
if it's not so, if it is not so urgent, then keep it for another day or next week. Will you be able to come on next week on physically?
Yes, yes. Yes, yes. My lord, I would like to address your lordship physically only, my lord, because
শুনি কেনেকে শুনিব কওকচোন It is matter, as per you, it's urgent. You're for the respondent, na?
Investigation, my lord. Investigation has been made. So ultimately, before the police station, if there is no offenses against him, the police will find that.
But this criminal petition is for quashing of the FIR. Is there any stay is operating?
Yes, my lord.
Oh. So okay, then do one thing. Yes, Mr. Dubey, when, sorry, you are Mr. Dubey, na? Yes,
Yes, yes,
Mr. Dubey, when you can come?
my lord, if your lordship
Today,
can take.
it's not quick.
It is now.
I understand, my lord. I also wanted to address your lordship physically, my lord, because there are certain judgments that I want to rely upon, my lord, that may be difficult placing before your lordship, my lord.
So for
Could
you,
be-
when it will be convenient? For
It
you?
would be on 15th of June, my lord, if it's not convenient to your lordships or my friend.
15 will be too late for them, I think, because
Yes, my lord.
matter is urgent and there is a stay is also operating. So injunction,
Lord,
I
it is
mean,
operating for
investigation
the
is not under
petitioner only,
progress, I
not
think.
in respect of the main accused, my lord. In fact, I'll address your lordship on this. Or could it, or lordship can take it on 12th, my lord? Because otherwise some fixed matters are there, my lord. That's the difficulty.
12 will do. Let him come physically, then if he wants to submit anything. And I also think that matter may be urgent because if stay is there.
Initial stage of investigation.
So you have you have received the case diary. Is it a scan copy or the case diary itself? Scan copy is there. So you can retain it, no issue on that. Oh, okay, then if it is a scan copy, 12th of June paribo niki? 12th of June is what day? Monday, Tuesday, Friday?
It's a Friday, my
It's a Friday, Lordship.
Friday again. Friday again, some problem we have. For all of us, we have some problem on Friday. So
Then, my lord,
can it
Monday,
be
my
on
lord,
10th?
15th, it could be, I could have accommodated, my lord. 10th, my lord,
10th,
some
10th. Can it be
NCLT
on
matters
10th?
are there. NCLT
The
matters
other
is there.
side council is saying, can it be on 10th?
But 10th, I have some difficulty. There are some fixed matters are there, which I have to do over here. Can it, let it be 15, my lord? I think 2 days will not make much of a difference for my learned friend, my lord.
15, I have a method, dear my lord. Let it be on 10, my lord.
Oh.
Come on 10th only. Will you physically you just appear on 10th? Because 12th, there may be some problem.
Lordship.
Generally, we issue less numbers of matters on Fridays.
I
So,
understand. Let it be 10th, my lord, then.
okay, then 10th. You physically you appear on 10th?
Yes, yes, I was supposed to come today only,
Just
but
tell us
because of
one
the
thing, Mr. Loi. Whatever the progress of the investigation for the other accused, is there any stay of the other accused or these are going on?
No, lordship, it's proceeded was about this present applicant only, lordship. He is not cooperating.
Cooperating. He is not
Lord,
even
if no
appearing.
case is made out against me, Lord, I am not to face, Lord, criminal proceeding, Lord. That I will not satisfy your lordship. In fact, if your lordship sees order dated 20.
Against him, let him appear and give his
Why,
statement.
Lord, I'll
If the
address this
police
on
find-
lordships. Otherwise, what is the purpose of filing a
find
quashing
no-
petition, Lord?
My lord, if police find no allegation against him, the FIR may be given against him. This is the initial stage of investigation, whether there is an offense or not offense. How do we know at this stage?
Well, I'll satisfy
If
your
there is-
lordships on this. That be the,
You-
what
you
my
given
learned
a-
friend is saying, Lord, if that could be the ratio, my lord, there would be no quashing in any of the FIRs, my lords. And your lordship has
My
been
lord, there is
pleased
a
to
written judgment is
consider
also
the
there.
prima facie case, then only, my lord, that interim order has been passed in my favor on 20th of January, my lord. I'll also demonstrate what is the role of the police in this case, my lords. But where the two of the accused have been brought in police stations, my lord, they have not been shown arrest by showing some different address, my lords. Notices has been issued to me, which has returned unserved, but then they were after me, my lord. And it's so far as my client is concerned, it's purely a civil dispute, my lord. His name has been dragged on, my lord. I'll address your lordships on these issues on 10th, my lord.
10th
Only
will
thing,
do.
Lord, the interim order is need to be continued till 10th, my lords.
Interim order be continued till next date of posting. Well, listing it on 10th, let us
Yeah,
see.
for final.
Okay then. Just come for, yes, for final disposal.
Deeply
And
aware.
it shall be made to dispose of the matter finally.
Item number 10.
Please. Well, this is this criminal petition is joint petition ma'am, for quashing of the GR 752 of 25 in connection with Narlagan PS case and the connected charge sheet ma'am. Yeah, my lord, the sections are 117(3) BNSS, 118(2) BNSS, 25(1) BA, and 27(1) of the Arms Act, my lord.
27, one of the arms act is also there.
My lord. Arms Act is
Now it is compromised.
compromised, my lord.
What?
My lord, that what happened, but the Arms Act as such, my lord, that it was an accidental firing, my lord, where a boy was injured, man. But immediately, my lord, on 27th August 2025, man,
and due to accidental firing in the garage, while the accused had gone there to repair his car. He was on his journey to his district, man.
So your petitioner number one is who is he?
One
he
is
is
the
the-
accused person, ma'am.
Two is the?
Two is the, my lord, informant, my lord, the landlord of the premise, man. Sorry, my lord. Two is the father of the victim, man. Victim was a 13-year-old child, my lord. And three is the informant, my lord, who owns that garage, my lord, that landlord. That it was an accidental firing, my lord. Immediately, my lord, the boy was taken to the hospital, and the accused also surrendered, my lord. And while the accused was in custody, my lord, on his instruction, the family took care of everything, my lord. The boy was discharged immediately the next day itself, my lord.
Well, injury report you have annexed here?
Injury, yes, injury. It's a charge sheet is also already there, my lord. Although it says grievous, my lord, it was accidentally, my lord, and it was hurt near the hip, my lord. And then but otherwise, after treatment, he was released the next day, my lord. No any serious injury had happened to the boy. Otherwise, the family of the accused person, while he was in custody, on his instructions, took care of everything, his medical treatment and everything. Now he was in the jail, my lord, judicial custody for around more than 4 months, my lord, around 5 months, my lord. And after that, he was granted bail. And after that, again, they have entered into another agreement with the accused person also. If you have lordship, I will take your lordship directly to the charge sheet, and then the statements, my lord, will see, my lord. At page 40 is the, my lord, victim, my lord. Statement of the victim. There was some defect with the gun. This statement so and so, Sri Andrivas Endover, age 13 years, son of Sri Manuel Endover, who is the father, my lord, in the petitioner number 2, my lord. On being examined, I stated at above location, so and so, my lord, that Sapna Garage is where the incident took place, my lord. Above location is my present permanent address. I have come to Naharlagan to stay with my nephew for, it should be uncle, my lord. Uncle is the person who is running the garage, man. And this victim is the nephew, man. Stay with my nephew for some time. On 27 at 2020, at 9:10 hours, I came to Sapna Garage with my uncle to see the garage repairing works of vehicle. At about 100 or 1000 hours, one Xylo car bearing registration number AS so and so come at that garage for repairing. My uncle Sri Hiren and Rover started the repairing of this vehicle, and I was standing near the car to see the repairing work. At about 5 minutes after to start the repairing work by my uncle, I heard a sound that may be a bomb or bullet. In the meantime, I feel pain in my hip and saw that blood is oozing. Blood is blowing from my hip, and the person who shot me from a short weapon, probably revolver, is also standing nearby me by holding a short weapon in his hand. In that time, many people who were working nearby that garage come there. After a few minutes, the accused who was fired on me wants to flee away from there. This was got nervous, my lord, after accident. And one of uncles, namely Sri Jugendas, has requested him to take me to TRIMS Naharlagan for necessary treatment. On his request, the accused later identified as so and so, the petitioner number 1, my lord, has taken away me to TRIMS Naharlagan for treatment. But when we reached that emergency, kept me on the bed of emergency ward and told me that he will come up here after meet a few people outside. Now that he has not returned one, and later I know that he had fled. Later my relatives and so and so, so and so. So he took with him to the hospital, my lord. And then the uncle, my lord, is at page 29, my lord, who runs the garage, my lord. It's the same statement, my lord, that my nephew was standing nearby. Suddenly there was a sound, my lord. The statement so and so, Hiren and over age 27 years, so and so. On being examined, I state that at above location is my present permanent address. On 27 at 1000 hours, one person driven by Xylo car bearing registration number AS so and so come at his Sapna garage located at Lower Model Village, Naharlagan, for repairing his vehicle. While I was repairing his vehicle, my nephew, namely Sri Andrews and over age 13 years, who was standing near the car to see the repair. At about 5 minutes after start my repairing, I heard a sound that may bomb or bullet. In the meantime, I saw that my nephew who was standing there, so and so is the same, that nothing happened, all of a sudden that sudden firing with them, because of the accidental firing. This happened. There's no enmity, nothing between them. And immediately that, initially he got nervous after seeing that the blood is coming out. No, but later he took that boy to the hospital also. And he kept the boy to the hospital, and since he got very nervous, he surrendered. Later on he surrendered also. Next day he surrendered before the police also. When it was declared that the boy was safe and he had been released, he surrendered also. And other witnesses are also there, my lord. At page 43, also is the employee of that garage, my lord. They also the same statement that all of a sudden there was a firing. Now, my lord, at page, if you lordship may come to page 19, my lord, annexure 1. This is immediately after that is the incident while the accused was in the custody, police custody. This agreement was on 4th of September 2025, and they took care of him and also bore all the expenses, medical expenses. And after being released from the judicial custody,
This agreement is between whom?
this was initially between the family members because the accused was in the custody, police custody. But at his instructions, the family members of the accused person, they took care of everything, and this agreement was entered into. And he was arrested in August, and in the month of December, 16 December, he was released, and they again entered into another agreement, which is at page 44, man. Since the accused was under custody, he could not enter into an agreement earlier, but at his instruction, his family member took care of everything, man. And except 3 page 44. This was a first agreement after the accused was released from the custody. Now this 117.3 is voluntarily causing grievous hurt, causing permanent disability, vegetative state. That is up to 10 years, madam. But here in this case, it's not even applicable, madam. The boy was released immediately. And 118.2 is grievous hurt also, madam, by dangerous weapon. Section 25, 1B is a possession of or carries firearm in contravention of section 3. This punishment is up to 5 years, my lord.
Yes, Mr.
The contravention of this is only up to maximum punishment is up to 5 years only. Here, what I'm submitting, my lord. The gun as such, my lord, it was gifted, my lord, of course. But before he could transfer, what happened is his mother was diagnosed with cancer. So because of that, he could not do the transfer also. Otherwise, it was legally gifted. The statement of the owner who gifted, my lord, that has been recorded.
The license was in whose name? Mother's?
The license was in other's name.
Father's name?
No, it is uncle.
Uncle's name?
Yes, a relative.
What? But still he was carrying the gun.
Yes, that gun was gifted. That I inherited the circumstances also. Because immediately after that, his mother was diagnosed with cancer, and then in the meantime, he took what? So, and after that, his mother passed away also in the month of July. And immediately 1 month after the passing of his mother, my lord, that incident happened. Now, because of that, he could not transfer the.
What bound him to carry this gun with him, even without transfer?
My lord.
What was the urgency? Is there any life threat to him or what?
No, my lord, he is a taxi driver basically. So
very good.
Yes, they travel to different places, and then say he's regularly ferrying from Dapurujo to here, my lord. And at times, my lord, they travel at night also, my lord. So there is some just for precautions, my lord, he was carrying, my lord. That otherwise the gift is also there, my lord. That 36, my lord, page 36, my lord. Page 36, my lord. It's the gun license and gifted and everything, my lord. Then, my lord, statement of the person who gifted, my lord, is at page 41. And the notary officer also at page 42, my lord. My lord will see, my lord, page 41, my lord, statement, my lord. It's not uncle, my lord, it's brother-in-law. On being examined, I stated at above location is my presence. So I have given my arms license to Sri Jiten Singh on good faith, as I know him to very well since long. In this regard, we have jointly made the deed of gift, deed of agreement before artist Sogum, notary officer, Upper Sulawesi district as a legal document for carry my arms only so that police may not disturb him. I have already advised him to apply for transfer of arms license on the basis of deed of agreement made before the notary.
If police disturb him, he will shoot him.
No, my lord.
Then?
No, this is so that.
So that police may not disturb him.
No, my lord. As legal, my lord, in this regard, we have jointly made a deed of agreement so that the police do not disturb him. Deed of agreement before Sri R.T. Sogum, notary officer, Upper Sulawesi district, Dapojo, as a legal document for carry arms only, so that the police may not disturb him. That agreement, my lord, he's talking about the agreement, so that it was made because he's not unnecessarily harassed. So just as a authority, he has made that agreement. That is what he is saying. And next page also, my lord, is the notary public is also there. He has also made the statement that it was made before him. Now, my lord, today what I'm submitting, my lord, this accident, my lord. Basically, otherwise from the statement also, my lord, it is only an accident, my lord. And the conduct of the
Okay, it seems to be accident undoubtedly because there was no such quarrel or nothing had happened.
conduct of
But question is that why he was carrying an unlicensed gun with him? That is the issue.
Yes,
So
ma'am.
by that
That
time, one day Bob
that
was
is
in
on-
danger.
No, my lord, that is on the basis of this gifted, my lord, only. He was supposed to apply for transfer, my lord. He could not do that, my lord. As I have stated in the petition also, my lord. In the meantime, his mother was diagnosed with cancer, my lord, and who later passed away also, my lord. Because of that, he could not do the further needful legal actions for transfer of this, my lord. Now, what the person has said is that the person who gifted has said that I made this document so that as a valid document to allow him to carry so that the police do not disturb him or harass him for carrying that. That's why I have made that agreement. That is what the person is also saying. And today, my lord, what I'm saying is that, my lord, the person otherwise, my lord, the conduct will also see how he is conducted. Immediately, he has taken care of everything. And then he has no, he's only a taxi driver, man. And now he has no criminal antecedent, nothing. And the offense as such, my lord, it might be serious, my lord. It's not heinous in nature, so, my lord, that settlement, it can be looked into, my lord. That is what I'm submitting.
Yes.
And then I'm relying on this Lakshmi Narayan and then K. Bharti Devi, my lord.
Yes, Lordship, difficulties, Lordship, during the occurrence, Lordship, you are not processed with the credit license. Otherwise, they have settled their there are 2 rounds of settlement, Lordship.
That's why, my lord, that person, that Tasabaki who gifted, he has said that I made the document that was made in
February.
my lord. Because so that since he did not possess a license as such at that moment, I made that so that to authorize him to carry. That's what he has also said. Now here I'm relying on this, my lord, Lakshmi Narayan and paragraph 14, my lord. Otherwise, my lord, the same, the principle remains the same, my lord, that At page 702, my lord.
Yes.
Paragraph 14, my lord. Now, so far as the conflict between the decision of this court in so and so is concerned in so and so, this court has noted the difference between the power of compounding of offences conferred on a court under section 320 CRPC and the powers conferred under section 482 CRPC for quashing of criminal proceedings by the High Court. In that said decision, this court further observed that in compounding the offences, the power of a criminal court is circumscribed by the provisions contained in section 320 CRPC, and the court is guided solely and squarely thereby. While on the other hand, the formation of opinion by the High Court for quashing criminal proceedings or criminal complaint under section 482 CRPC is guided by the material on record as to whether ends of justice justify such exercise of power, although ultimate consequence may be acquittal or dismissal of indictment. However, in the subsequent case of so and so, the very bench so and so. There, my lord, that this principles has been laid down, and now, my lord, I may read, my lord. In view of the aforesaid discussions, we sum up and lay down the following principles by which the High Court would be guided by giving adequate treatment to the settlement between the parties and exercising its power under 482 of the court while accepting the settlement and quashing the proceedings or refusing to accept the settlement with direction to continue the criminal proceedings. 29.1. Power under section conferred under section 482 of the court is to be distinguished from the power which lies. So, my lord, we come to 29.2. When the parties have reached the settlement on that basis, petition for quashing the criminal proceedings is filed. The guiding factor in such cases would be to secure ends of justice or to prevent abuse of the process of any court. While exercising the powers, the High Court is to form an opinion on either of the aforesaid two objectives, my lord. Yeah, my lord, my submission, humble submission, my lord. Ends of justice would be, my lord, in fact, met, my lord, if this quashed and the victim is accused is not required to undergo the criminal trial. 29.3, my lord. Such a power is not to exercise in those prosecutions which involve heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc. Such offences are not private in nature and have a serious impact on society. Similarly, for offences alleged to have been committed under a special statute like Prevention of Corruption Act or the offences committed by public servants while working in that capacity are not to be quashed merely on the basis of compromise between the victim and the offender. Then 29.5, while exercising its powers, the High Court is examined as to whether the possibility of conviction is remote and bleak, and continuation of criminal cases would put the accused to great oppression, prejudice, and extreme injustice would be caused by him by not quashing the criminal cases.
Okay, we'll continue. Just for 5 minutes. I'm getting discomfort with the chair.
Yes, my lord, I will not burden your lordship with all these things, my lord. But what has been said, my lord, for heinous offences, my lord, that rape, murder, dacoity, etc., my lord, this should not be. And what should be looked into is what was the stage of the settlement, etc., and what are the criminal antecedents, my lord. Now, my lord, the issue here is, of course, I do not possess a license. That is admitted fact, my lord. But, my lord, under the Act, Arms Act also, my lord, under Section 3, my lord, it authorizes a person, my lord, it gives a power or to authorize also, my lord, to carry that gun also, my lord. Now, that agreement, my lord, and the statement your lordship has seen, my lord, that also said the person would made that agreement. He also said, my lord, I had made that agreement so as to authorize him to carry and so that he is not harassed, my lord. So, my lord, my only prayer, my lord, is a person, my lord, he doesn't have any criminal antecedent, my lord. It was an accident, my lord. And the circumstances, my lord, because of which he could not apply for the transfer of the gun or the license also, my lord. That also I have merited, my lord. How he could not do that, my lord. And so, my lord, will consider this, my lord, with benevolence, my lord. Because this person, my lord, is my lord, a taxi driver, my lord. And then his family to support also, my lord. My lord will take all these things into consideration, how the accident occurred, my lord. And whether it's not a case, man, where I had illegally procured a gun and I was carrying it, man. It was a license that was bought under a gun that was bought under a valid license issued to, of course, to some other person, my lord. And that person had, my lord, made an agreement with me. And the statement also corroborates, my lord, where he has
Okay,
said,
yes, okay, I have heard.
I'll pray, my lord, that it may be caused, my lord, that charge sheet has been filed in, my lord, that
Under
now
which
this-
section, sir, such it?
my lord,
Same sections?
Same sections, my lord, same sections, my lord. And now that's JR 752 of 2025, my lord. It is still pending CC, my lord, consideration of charge. I will pray, my lord, that considering the facts, my lord, and this may be questioned.
Yes, want to submit then.
Lordship, that was lordship, since during the course of operation, he has not possessed the gun license, lordship. And lordship, whether this agreement is lordship maintainable or I'll leave it to the lordship.
Of course, now these persons, my lord, they are, my lord, not very educated persons, my lord. So they thought, my lord, basing on this, my lord, he will procure those things, my lord, that further transfer and etc. valid proceedings, procedure he will follow, man. They just thought that this is how it's to be done, and they made an agreement, and the person who is the license holder authorized this person, the accused, under that agreement only.
Heard Mr. D. Soki, the learned counsel for the petitioner, also heard Mr. D. Lloyd, the learned PP, appearing for the state respondent. This is an application, so and so, so and so. Paribana? For quashing of it was a heading for GR case number so and so, including the acquired and charge sheet. That likha ase quashing for GR case number so and so under section so and so pending before the court of Bulanet JMFC UPA. Next one, it is submitted by Mr. Sophie that the present petition for quashing is filed jointly by the accused petitioner number 1. Who is the informant in this case?
Informant is the landlord, madam, the owner of the
So
person.
number 3,
Number 3, madam.
the informant, that is the petitioner number 3, and the father of the victim, the petitioner number 2. It is submitted that from the statement made by the victim as well as the witnesses, it clearly reveals that it was merely an accident and there was no intention of the present petitioner to cause any harm to the victim, who is only a 13-year-old boy. From the statement by the victim also, it is seen that at the time of incident, he was observing the repairing works of one vehicle in the garage of his uncle, when suddenly he sustained bullet injury, and he saw that the blood is coming out from his hip region. But after thereafter, the accused himself took him to the hospital for treatment, and the family members of the accused also provided all necessary treatment to the victim, and he he was immediately released from the hospital without any grievous injury on his person. He further submitted from the circumstances and situation of this case, it is also seen that there was no quarrel or there was no any enmity with the informant or victim or the garage owner, that is the petitioner number 3, and it was purely an accidental when the bullet was coming out from the revolver which was holding by the accused at the time of incident. Next para. He further submitted that the arms belong to one of his belonged to his brother-in-law, and he was which was gifted to him. And in that process, there was also a gift deed executed by the owner of the gun. But subsequently, the process for transfer of the license in the name of the present petitioner could not be done due to sudden demise of due to ill health condition of his mother, who was suffering from cancer at the relevant time of incident. Soon after the incident, the family members and the father of the victim, as well as the garage owner, had entered into an agreement, and they also took all responsibility for treatment of the victim. But the accused could not put his signature during that time, as he was inside the jail. But after coming out from the jail, after at about 4-5 months, he and then a second and subsequent agreement was again executed, wherein the petitioner put his signatures in the subsequent mutual agreement. The situation and the subsequent conduct of the accused petitioner shows that it was a purely an accidental case wherein wherein suddenly the victim sustained bullet injury first. At first, as the matter has already been compromised between the parties, there is no chance of adducing evidence against the accused petitioner, and in that case, the probability of conviction is very remote and bleak, even if the even if the case is allowed to be proceeded further. Mr. Soki further relied on two decisions of the apex court passed in case of Lakshmi Narayan, which is reported in 2019 5 SCC 688. State of birth so Lakshmi Narayan so, wherein in para 14 there was para 14 not exactly 14
Yes, 14 and 15.
কি দিলে লক্ষ্মী নারায়ণ Even well, in para 14 and 15, there are some guidelines. There are some guidelines passed by the Apex Court while dealing with a petition under section 482. 482 CRPC corresponding to section 528 of BNSS. To stop. We further relied on the decision of Apex, another decision of the Apex Court passed in case of K. Bharati Devi and another versus state of Telangana and another. Here you have
Para 40, my lord. Page 400, my lord.
Same.
Same, my lord.
Wherein also the order was passed for quashing considering the two judges bench of the Apex Court passed in case of Narinder Singh, NINA, RINDER, Narinder Singh, wherein which was reiterated in the case of Lakshmi Narayan Supra. Next para, citing the above referred judgment is submitted by Mr. Sophie that the considering the entire situation and circumstances of this case, the matter may be the case pending before the JMF's case of that case, that is the GR case number so and so pending before the learned JMFC UPA may be set aside and quashed. He further submitted that he was also not carrying the gun unauthorizedly, as there was an agreement where there was an gift agreement which was executed by the owner of the gun, and he himself stated before the IO investigating officer that that agreement was executed so that he can carry the gun and also to avoid from any disturbances from police. Mr. Stoki accordingly submitted that this is a fit case wherein the entire proceeding pending before the learned GMFC in connection with GR case number 752/2025 under section so and so may be set aside and quashed. Next para, Mr. Loyi, the learned PP submitted in this regard that there may be compromise between the parties, but from the materials available in the record, it reveals that at the time of the incident, the license was not in the name of the petitioner, and there was and the registration of the license was still in the name of another person. Thus, he was unauthorized carrying the gun at the relevant time of incident. And Mr. Loyi accordingly raised objection and submitted that it may not be a fit case to extend, it may not be a fit case for quashing by invoking the power under section 528 of BNSS. He did with baki him only. We have recorded your submission and pass the order.
My lord will consider whether that unauthorized or not. For this, and then the facts and circumstances matter, and the life of a young guy matter.
Can see to it.
All that.
Good chamber DP last of Hindi was.
Item number 5, passable matter.
Disposed by the Khadiba.
Your lordship, the counsel for the petitioner has left the court premises. Yes. So the matter may be fixed for some other day, your lordship.
No, why we are calling you? You're for the petitioner?
No, for the respondent, your lordship.
Again for the respondent?
Yes, on behalf of the Tamok who appeared before me. He's my senior, Your Lordship.
If okay, none appears on call for the petitioner. List the matter accordingly when it can be listed.
Fix their lordship
Video
after a week.
after a week as an petition.
Much obliged, Your Lord.
Item number 11.
Yes.
Your Lordship, there is a application for the passing of this fire. Passing
Of?
FIR.
FIR.
Someone.
Someone?
Yes, Your Lordship. My ground for challenging this someone that this someone has been sued without the registration of the FIR. And second is that this has been
Registration of the FIR.
without registration of the FIR. On the basis of the GD entry. If someone has been issued, there is
By court,
no,
by police.
yes, only.
It says summon or notice. What is it?
No, no, notice.
35 notice.
Notice of the
Yes, 35 notice only.
without registration. There is no mention of under which section, Your Lordship, the offence has been alleged against me. And second, Your Lordship,
It cannot be, as per you cannot.
no, Your Lordship. FIR has to be registered first, then only this notice of appearance can be issued. And second, the ground which I'm
For inquiry also, you cannot be asked to appear or what? Suppose a matter is there, it is not registered because in some cases there needs some preliminary investigation also. In that case also, you can say, you are saying that notice is, you cannot authorize to issue a notice.
without registration of the, at least you have the allegation. has
Do you
been-
have any authority in that regard?
Your Lordship, the first thing that, and the second thing is that
Just a second.
notice of appearance has been issued through WhatsApp and electronic media. And as per the Satyendra Antil Kumar, there can be any notice or someone cannot be.
So you don't want to cooperate?
No, Your Lordship,
That's what you are saying?
no, Your Lordship, that is not there.
Then to warrant of arrest has to be there otherwise.
In terms of last order, the status report was 4 19 to 2026. Before was 4.
No, notice was issued on 35(3), I think, na?
Yes, my lord. My lord, to my lord, humble understanding, my lord, this aspect has been dealt by our own court, my lord. That whether prior to the registration of the FIR, whether this summon can be issued or not, my lord. So far as 35 is concerned, my lord, is very clear. 35 cannot be issued, my lord. Because, my lord, what this guideline laid by the Supreme Court in, my lord, this Lalita Kumari case, my lord. In Lalita Kumari case, my lord, the Supreme Court has held that the investigation authority can carry out preliminary inquiry not to find out the veracity of the allegation, my lord, only to see whether the FIR or the complaint disclosed commission of cognizable offense or not, my lord. To that extent only, my lord. A limited scope is there. And that, my lord, the same issue has come up before the coordinate bench, my lord. And the coordinate bench has rendered judgment, my lord. If, my lord, this matter may pass over for the time being, then, my lord, I will come with the judgment, my lord. Because, my lord, here we have received an status report, my lord. Though it is in March, here the investigation authority, inquiry officer is saying that initially it was issued under 35(3) mistakenly, and it is to be construed as 179 under summon, my lord. They too, my lord, in my humble understanding, is not correct position of law, my lord. I will just rely that or refer the judgment of the coordinate bench, my lord. Just pass over for the time being, my lord.
Item number 12.
Yes.
My lord, service is not completed, my lord. Because it involved POXO matter, my lord. Although, my lord, we have received the case diary here. And so far as case diary is concerned, my lord, there is no.
Do one thing.
Yes.
We need the service and make an inquiry otherwise regarding the service from your office.
Yes, my lord. My lord, the WT message reply is there, my lord. Actually, what has happened in this case, my lord, when the notice was issued, My lord, it was perhaps sent late from our side, my lord. So on the next date, my lord, they actually it reached late, my lord. So because of that, they could not be able to serve the
Okay,
notice.
okay, already there.
Yes, my lord. So my lord, in that case, my lord, let them take fresh step. Again, we'll take steps, my lord, or my lord will take instruction from the concerned IO, my lord, whether it can be served or not, my lord, because they have the
If
copy of.
suppose on late received day may not be, because, so better to take a fresh step.
Yes, my lord.
It is
My-
within Naharlagun or?
No, my lord, in Lumla, my lord, Tawang district.
My lord, it's very
Yes.
far.
It's very far, my lord.
It's near the Bhutan border.
So you have received the case diary.
I have received the case
In
diary, my
that
lord.
case, you are going to retain it or what?
My lord, actually, on last occasion only, my lord, CD was received.
Oh, last occasion.
Yes, my lord. On the last occasion also, my lord, the service was not completed, my lord. And I have gone through the, my lord, case diary also, my lord. As on that, my lord, there is no any incriminating material against the accused. As on the last date, my lord. Or otherwise, my lord may call for the up-to-date case diary also, my lord, along with the service report.
It is otherwise AB, na?
Yes, my lord. And he is
there
already
any-
protected.
Is there any interim? Oh, you are already?
Yes, ma'am.
Okay, then. Then
My
yes,
name
we
is
can
there
read.
only in the FIR because the person who has committed the alleged act is my employee, the main accused.
And the victim was
So-
staying at his residence.
Yes.
That much only is the, my lord, allegation. The narration in the FIR, not direct allegation against him. Man.
So anyway, you're protected, na?
Yes, my lord.
You're Mr.
HK Jamu, my lord.
Heard Mr. H.K. Jamu, the learned counsel for the petition. Also heard Mr. Chiete, the learned additional PP, appearing on behalf of said respondent. CD received, however, it is seen from the W2 message that the notice could not be served on the respondent as it was received late by the concerned police station. In view of this, the petitioner is hereby directed to take fresh steps through Office of the Registry and the Public Prosecutor, and the concerned jurisdictional police station is also hereby asked to serve the copy within time. Let the CD be returned, calling for an updated one. At least when it can be listed.
My lord,
You want any fixed date here? You should be fixed
Yes,
date here.
my lord,
actually.
fix that, my lord. Today is first, my lord.
It will be 8,
can it
9,
be on
10.
23rd June?
20, that will be too long.
Let it be on, my lord, 8 or 9, my lord.
But if you return back the case, will you get?
Then,
the
my lord,
updated
on,
one?
my lord, 15 then, my lord.
It will be on 15.
15.
It's very far from each
Fine,
another.
that's fine. I'm
Yes, ma'am.
15 corridor. Interim be continued till next date of list.
Highly obliged,
Continue.
deeply obliged.
Item number 13.
May it please your lordship. Lordship, item 13.
Yes.
Lordship,
Item
it is an-
13.
Yes, lordship, it is an anticipatory bail application, lordship. On previous occasion, lordship, on 11/5/26, I was granted interim and the CD was called for, lordship.
Then what had happened?
Lordship, it is a matter of financial misappropriation, lordship. We
No,
have
no, no.
com-
Why I is there? One I is there.
Lordship, yes, lordship, in compliance with the order dated 11/5/26, we had gone to Daporizo police station to comply with all the terms and conditions mentioned in the interim order. So when in the police station, lordship, first of all, we were, despite there being an order, we were made to sit in the police station for around 7.5, 8 hours, lordship, without our statement being recorded. Then, lordship, I went with my friend who was also my bailer. Despite that, lordship, the officer in charge at the police station extorted an amount of rupees 30,000. He said, despite my friend's documents were kept as bailer's document as surety, 30,000 was extorted, saying that 20,000 is for bail and another 10,000 for his travel expenses because he had come to Lakhimpur for investigation, lordship. Lordship, you find in the Annexure A of the IA, lordship. We have also filed a complaint with the superintendent of Daporizo. Page 13 of the IA, lordship. This is the transaction. This is the Google Pay transaction. Officer in charge's name is also reflected here, Tali Kai.
30,000 was paid.
Yes, I
You have
had
paid
to.
already 30,000.
Yes, because I was detained in the police station, and because of that pressure, I was forced to pay that amount despite my bailer being there with me. This is my bailer paying the amount to the officer in charge in the police station, Lordship.
Thereafter, what had happened?
Thereafter, my signatures were my bailer signatures were taken, documents were taken, everything, every formality was completed, but they extorted this 30,000 rupees. Therefore, Lordship, on last occasion we filed the IA. We also have filed a complaint with the superintendent of Daporizo Police.
But till date, your statement is not recorded.
No. No.
Without recording most of the.
Whether that can be done by now at this stage.
Lordship,
What do you want to submit in that case? Because there is a clear complaint brought against your officer.
yes, Lordship.
I mean, the police
Very
officer.
serious,
Yes.
serious
Serious concern,
allegations. Yes.
So as per you have already filed a complaint before the SP, Superintendent of Police.
Yes, Lordship.
So is there any progress? What had happened subsequently?
Lordship, we have sent it through post because I'm currently in Lakhimpur, and going to Daporizo would only complicate matters more for me because I'm apprehensive. So the application is still in transit. We have also mailed them, but we have not received any reply as of yet.
Yes,
We
Mr.
didn't
Rao,
also
what to
receive
do?
CD, Lordship.
Pardon?
We didn't receive CD also, Lordship.
And take the instructions also, what had happened. They have filed only
yes.
one I also.
Yes, Lordship. On the last occasion, one of my colleagues appeared, so I'm not updated with this matter. Otherwise, I will, Lordship. I will seek instruction, Lordship.
Otherwise, they were on interim, so they are supposed to appear before the IO and to record the statement
Yes.
and also to cooperate.
Yes.
But instead of allowing doing so, you are asking money, and that part
It's very
they have already filed that
Lordship.
30,000 has already been paid. That should not be.
Yes, Lordship.
Lordship, I may be protected in the interim.
Continue.
Lordship may continue the order.
You are MS?
D. Dotto.
What's your good name?
D. Dotto, Lordship.
Account naam reflect.
Yes, Lordship, name is also not showing. My name is there in the Wakalatnama, but it is not showing in the matter for some reason.
D. Heard MS D. Doctor, the learned counsel for the petitioner, also heard Mr. D. Louis, the learned PP appearing for the state respondent. It is submitted by Mr. Louis that the CD not received. However, in that case, it is submitted by Mr. MS Doctor that the statement of the accused petitioner is also not recorded by the investigating officer, and rather they demanded rupees 35,000, stating that why demanded? What was the reason?
They
One
said that
is for one.
yes, traveling expenses, they said, because they had to come to Lakhimpur to investigate the matter, and 20,000 they said is the bail amount, despite my bailer being present there.
And also asked for and saying that 20,000 is required for as a bail amount, and another amount will be required as his transportation allowance, as he had to come to Lakhimpur for investigation. Thus, it is alleged that they have the investigating officer had extorted money from the present petitioner, despite being the presence of the bailer, and they have also not recorded the statement of the victim, the accused. In that regard, they have already filed one IA, which has already been registered as IA criminal 33/2026. In view of this, next para, Mr. Loy, the learned additional PP submitted in this regard, that he will call for a report from the concerned. You report may be called for from
Yes,
the
yes,
investigating, or
yes,
report
yes.
may be called for from the investigating officer. And to, if required, the explanation may also be called for. A report may be called for from the concerned police station, and he also paid for time seeking and so sought for time to produce the case diary before the court concerned. Next para, considering the entire submission made by counsel appearing for the petitioner, the investigating officer is hereby directed to immediately record the statement of the accused petitioner, and also to furnish a report as a report oblique explanation as to what had happened when the petitioner appeared before the police station with the bailer, and for what reason the bail bond could not be was not accepted, and the petitioner's statement was not recorded by the investigating officer. Let an updated case diary be called for and list the matter accordingly. Take some time.
On 10, Lordship.
That will
Intent
do.
may continue.
Yes, Lordship.
That will do.
Yes. But then, Lordship, be it on 15, Lordship.
Let it be on 15.
Will have-
Yes. List the matter accordingly on 15 6 2026, and interim be continued till next date of listing. Okay.
Definitely.
Item number 14.
Yes.
We are putting, we are standing on.
Huh?
Parking matter.
Petitioner department.
Yes. We are under instruction to withdraw the case file.
Withdraw.
Instructions.
Infractions.
Yes, my lord. Payment has been made.
Acha, payment is.
This order.
Pardon?
This order made.
Acha. Ha, yes, yes. Okay. Okay. Enough then. This was in regards to some payment, I think.
Yes, my lord. Regarding some bills, pending bills.
Pending bills. That has already been.
It has already sanctioned and paid.
Heard, you are Mr.
Jamo, my lord. Standing counsel for
T. Jamo for the food and civil supply. T. Jamo, the learned standing counsel for food and supplies department for the petitioner, review petitioner, and also heard Mr. S.K. Devi, the learned counsel, appearing for the respondent. It is submitted by Mr. Jamo that the money has already been paid. The bill amount has already been paid, and hence, as per the instructions of the department concerned, he is authorized to withdraw the case. Mr. Deuri directed to withdraw the case, and further, Mr. Deuri, the learned counsel for the respondent, also submitted that the payment has already been made, and he has no objection to that. Considering this submission made by learned counsel for both sides, the matter is accordingly disposed of on withdrawal, and the copy of the letter addressed to Mr. Jamo be kept as part of the record.
Obliged.
Item number 17.
আজি আপোনাক ৰিলিফ দিবৰ কাৰণে কোনো নাহি নেকি মানুহ? এইটো বুলি জনা হলেতো আমি আৰু এজন আনিব পাৰিলোহেঁতেন, তেতিয়াহ'লে বৰ্মন আহিব পাৰিলোহেঁতেন। মানুহ নাই সিহঁতৰ। আপোনালোকৰ মানুহ নাই নেকি আজিকালি? আপোনালোকৰ এতিয়া কোনো
থাকিবতো লাগিল। ৰিলিফটো মই কৈ দিম, Lordship। তেওঁ মোক সুধিছিলো তেওঁক বাৰু অকলে আছেনে আনিছো বোলো অকলে আছে মই ৰিপ্লেচমেণ্টৰ কাৰণে সুধিলো দূৰত মই কোন কোন গৈছো মই খবৰ লৈ দিম 4জন গৈছে তাতে আছে বাৰু 6জন আছে তথাপি আছে মই খবৰ কৰিম হয় দিগদাৰী হৈ
মই তাকে ভাবিছো কি হ'ল কথাটো মানুহ নাই বুলি কয় নাযায়
মই খবৰ এটা
একজনে আছে others are only বৰবত
I'm not aware মই খবৰ
চবকেতো একেলগে লিভ দিয়াৰ কুৱেশ্যনো নাহে there has to be someone না all are ladies if they go for leave for all of them one week maybe চববিলাক একেলগে গ'লে কেনেকে হয় যদি নহয় তেতিয়াহ'লে বৰ্মনক আহিব দিব will not possible on our part no if that is the condition keep one number 17 yes
Please, your ladies, I'm for the respondent number 1 and 2. I am yet to file my affidavit in opposition.
for respond number 1
1
and 2
and 2. Some delay took place, as your ladyship. There was a mediation on 29 May. Unfortunately, both the petitioner and the respondent could not amicably settle. This is a land dispute case. So I need
mediation was already there
there.
but it was not successful
It was not successful. It was recently held on 29, last Friday. So my affidavit in opposition is almost ready. So I need some more time to file affidavit in opposition on behalf of respondent number 1 and 2, which I am representing in this case. So I may be given some time. This matter may be fixed after 3 weeks. This is my prayer.
do one thing it's only 10 minutes to 1 so let him complete till 1 and then you come okay because from morning to since he is taking so no one is here now only you why it had happened oral leave how many oral leaves just tell us 4 5 they are out of station yes maternity one is on maternity and two are you if I could not have the position here then my other PS would have accompanied me but I thought that it's available only one will do but now I have come to know this is the situation okay then you do one thing from 2 onwards you just stay otherwise he will complete for till 1 okay yeah Mr.
Rena.
Huh?
Rena, on behalf of Vedanta Kosik.
J. Rena. Had Mr. J. Rena appearing on behalf of Mr. B. Kaushik, Tilane counsel for the petitioner. And also you are Parasaji, na?
I'm for the respondent.
You are Parasaji? You are?
Yes.
And also heard Mr. A. Parasaji appearing on behalf of respondent number 1 and 2, na? 1 and 2 and submitted that he needs at least 3 weeks time.
Later maybe fix after 3 weeks. In
3
between,
weeks
I'll
time.
file my
3 weeks time to file his affidavit in opposition. He further submitted that there was a delay in filing the affidavit as the matter was sent for mediation, but it was unsuccessful. And at present, he is going to file his affidavit in opposition within 3 weeks. In view of this, let the matter be accordingly listed after 3 weeks, enabling the petitioner, so respondent number 1 and 2 to file their affidavit in opposition.
Your Honor, there is an interim.
Interim be continued till next date of posting.
Much okay.
Item number 18.
INE. What is it I for?
Your Honor. Your Honor,
I is
actually,
for?
This I is for the 490 days of delay, Your Honor.
Delay?
Yes, Your
Oh,
Honor.
acha.
Condonation of delay, Your Honor.
Acha. You are appealing for the other side.
By this application, I am requesting the discretion of Honorable Court to condone my 490 days
I have been continuously pursuing this particular matter below trial court as well as the district court, Your Honor, mistakenly, Your Honor. So I have come with this application for delay of 490 days, which has been explained in
Which
para
para?
6 and page number 5 of the application.
Para 6.
Yes, of the IA, Your Honor.
Ah, yes, yes. Para?
Page number. Para number.
Para 6, yes.
Yes, para 6 and page number 5 of the 5.
5 is not report.
Is the table is the explanation in table, Your Honor, how the delay happened, Your Honor. In this particular case, Your Honor, I am 89 years old, almost 90 now, Your Honor. I had challenged village Kaba decision in the Isyang district, Rani village, Your Honor. During that time, Your Honor, two village level Kabangs happened on my instance. Both of them had been decided against me.
Against you?
Yes, Your Honor. So on 2019, one was on 27th and one was on 4th of July. Yes, Your Honor. It was decided on 4th of July, first decision. Thereafter, another was decided on 27th August
No,
2019.
after decision on 4th of July, again you approached the same petition again.
Yes, Your Honor.
You did not approach any appellate forum.
Your Honor, I had approached the appellate forum on 23rd 9, 2019, Your Honor.
That is after the two decision.
Your Honor.
No, I'm saying that when your first decision was against you,
Your Honor.
then on the same ground you again approached the Kebang for the second one.
This is the facts of the case, Your Honor. I'm narrating, Your Honor. The village level decision was on the first instant, it was objected by me. And again, a Kebang was held, and accordingly, both the parties again appeared, and both the parties appeared, and again another decision was passed. So, of this 27/8/19 decision, I had challenged it in the Deputy Commissioner Court, Your Honor. As at that time in 2019, Your Honor, under
No, two decision, one is on 4th and one is on 7th of July only.
Your Honor. No, one is on August, Your Honor.
One is on 4th of July
Your Honor.
and other one is
On 27th of August, Your Honor.
27th of August.
Yes, because on 4th of July, the decision was not concluded, Your Honor. So accordingly, on 27 August, the village authority had asked for additional documents if any party has, and accordingly, on 27th of August, Your Honor, the village authorities had, based upon one piece of document of 1988, and accordingly, the respondents were given the rights as per the village authority of 2017, Your Honor. This particular decision was challenged by me in a form of DC Kebang Appeal number 10 of 2019. At that time, Your Honor, there was no APCC Act, only AFR was running. It was filed under Section 46 of AFR, Your Honor, as per the procedure that time followed by the Isyang district, Your Honor, Adi Belt, Your Honor. So accordingly, Your Honor, the matter was kept pending out there, but on 2012, April 2021, APCC Act was notified, and accordingly, this Act was adopted by the state of Arunachal Pradesh, affecting the Kebang jurisdiction and all. Accordingly, Your Honor, the matters were, it came into force and pending appeals transferred to the civil courts. All the the matters were transferred to the civil courts, Your Honor. Another amendment was again circulated in 2022 as well as 2023. Accordingly, the appeal was renumbered as Civil Kaba Appeal at 09 of 23 at the senior civil judge at Pasigat, Your Honor. So this particular Kaba appeal had ultimately numbered as 09 of 23, and it was decided by the Civil Judge Senior Division on 11/6/2024, and I am coming before this honorable court challenging this particular impugned order. But before that, Your Honor, I had filed another, after the decision of 11/6/24, I had filed another review petition at the same court. If I can just bring the attention of this honorable court to page number 9 of the IA, Your Honor.
Yes.
Page number 9, Annexure 1A1, Your Honor. This is the decision, Your Honor. Order dated 11/6/24. Detail. Herein it is been mentioned that it is held that there has been no violation of principle of natural justice. There is no infirmity in the Kaba decision dated 27/8/2019, which is just and reasonable, and the same is upheld as it is based on principle of adverse position. So, Your Honor, on 11/6/2024, after I have formally filed an appeal, the honorable court never went to calling of witnesses, never went through that particular 1988 piece of document which was relied upon. It was never verified.
Okay, these are the merits of the case we'll consider. Now, after the order on 11/6/2024, which has been challenged by you now,
Your Honor.
but there was 490 days.
Your Honor.
Whatever you have explained, that one.
To explain that, Your
Rest
Honor,
will come at the time of discussing the merit on the connected CRP.
Your Honor.
Yes.
If we
Why
come to-
delay
if I-
it there?
If we come to page number 6, Your Honor, again of the IA, the background of the case is on 11/6/2024, the decision was passed in table, Your Honor.
Yes, yes.
First one. Before limitation expired, that is within 30 days, 11/6/24, the decision was passed by the civil judge. And I had filed a review application on 3/7/24, Your Honor, within limitation, Your Honor. Accordingly, it was admitted. Accordingly, it was going through, Your Honor.
As per you, you file your review on 3/7.
3/7/2024, Your Honor. And it was admitted, education was going on, and it was ultimately deliberated on 7/1/2025.
Review before the
Same court, Your Honor. Same civil judge senior division, Your Honor. So, Your Honor, accordingly, Your Honor, 188 days of delay had happened during this hearing proceeding, Your Honor, of the review. Thereafter, Your Honor, it was ultimately decided on 7/1/2025, Your Honor. Thereafter, Your Honor, I being of limited knowledge as the petitioner, Your Honor, I had filed a second appeal, Your Honor, with bona fide intentions, because out there in the district courts, Your Honor, second appeal, because at this time, Your Honor, APCC Act was applicable. So accordingly, going through the prospective application of law, I had applied and preferred an second appeal, Your Honor, within,
as per whose advice? As per your advice?
Your Honor, 15th As per, Your Honor, section
One
50
forum may be wrong, but we'll do it the second, subsequent, third, every forum. If you approach a wrong forum, how will you do?
Your Honor,
Then
I sincerely bow down to that particular, Your Honor, query, Your Honor. I had bona fidely applied and preferred this second appeal, Your Honor, but ultimately the lower court below had said that no, this is not maintainable out there. You need to go to High Court for under section 100, or you need to ask the High Court for supervisory intervention because this is not maintainable at this honorable corner. So accordingly, Your Honor, during the second appeal also, Your Honor, it was filed on 4/2/2025 and it was deliberated on 9/9/2025. And then again, 400 or 217 days of delay happened, Your Honor. And within the filing of the review and the filing of the second appeal and applying for the certified copies, Your Honor, 28 days had happened, Your Honor. The delays had happened. Accordingly, Your Honor, I'm calculating, Your Honor, 188 days, 217 days, plus 28 days is equal to 433 days, Your Honor. And thereafter, Your Honor, I'm calculating this calculating from 11/6/2024 till the filing of this particular CRP on 14/10/2025, Your Honor. It comes to 490 days, Your Honor. So, Your Honor, I request this honorable court, Your Honor. Your Honor, the honorable court might apply the discretionary power in this particular IA, Your Honor, and kindly condone my 490 days as I am a all ailing private individual, Your Honor. If this IA is allowed, Your Honor, I can proceed towards the CRP, Your Honor. And this particular IA has been pending since October of 2025. Respondent number 1 has appeared on 2 occasions previously, but he is not appearing today itself. But my friend,
You are appearing
respondent
for
number
whom?
respondent number 2.
Respondent number
2.
1 is where?
Respondent number
1, I believe, my lord is not interested to pursue this condonation petition. So I have spoken to the counsel for the respondent number 1, and he had agreed to the whatever submission I make.
Acha, okay then. That will do for him.
Yes,
Okay, then we'll hear at 2.
my lord, oblige.
So I have heard you. So these are the points that you made some appeal or applications before some wrong forum.
Your Honor.
So basically, most probably that is the reason for your delay.
Your Honor, this particular Your Honor, condemnation of delay is only with respect to those delays which I have made bona fidely, Your Honor. It was never malified. It was bona fidely made, Your Honor. Since in our district, still the application of APCC Act, still a big confusion, Your Honor. Your Honor, even as per the Limitations Act also, I've just gone through the acts, Your Honor, and I've mentioned in para number 6 also, Your Honor. I am completely in the hands of this honorable court and the exercise of the discretionary power of this ladyship, Your Honor, that as per section 12, 14 and 5, Your Honor, if my condonation of delay application is allowed, Your Honor, we can proceed to the CRP. And for this act, Your Honor, I will be sincerely gracious and thankful to this honorable court. And with respect to that, Your Honor, certain citations which are
settled position of law, collector land acquisition, 1987, volume 2 SCC 107, Your Honor. Thereafter Balakrishnan and Krishnamurthy, 1998, 7 SCC 120, 123, and One Court of India Insurance Company Limited, Nirmala Devi, 1979. These are all settled position of law, Your Honor. When a person bona fidely makes a certain mistake and in a case, as per section 12, exclusion of time to legal proceedings, Your Honor, it is the settled position of law is that Supreme Court is numerous authorities has maintained the position of liberal approach, Your Honor, regarding this kind of applications, Your Honor. And accordingly, again, section 14, Your Honor, exclusion of time of proceeding bona fide in con without jurisdiction, Your Honor. Same position has been appreciated by the Supreme Court, Your Honor, and liberal approach. And I repeat, this honorable court can kindly condone my delay, Your Honor. At this stage, I have this much to say.
Yes.
May I please my lord, my objection to this condonation of delay petition is basically on certain grounds, such as, my lord, the grounds in the entire application, there is no whisper about, even after calculating and subtracting the days spent in the judicial forums, there's another delay that they have admitted themselves, 57 days. There's no whisper at all how this delay of 57 days has been explained, although the entirety is of 490 days. More so, my lord may kindly come to paragraph 4 of the application. May I read? Paragraph 4 said that thereafter, under a bona fide belief and due to limited legal knowledge, the petitioner preferred second CK, that is Kabang appeal, dated number such and such, before the learned district court Pasighat on dated such and such, which was subsequently dismissed on 9/9/2025 as non-maintainable. My lord, can an ignorance of law of the council can be a ground for condemnation? This aspect also has to be taken into consideration. There is no, in the interact, this doesn't cover under section 5 or section 12 or section 14 of the Limitation Act. So he has himself admitted. More so, Your Honor, if we see the non-maintainability of this appeal, which was non-maintainable, they have annexed this on dismissal of annexure A3 at page number 35 to 38. And I'm coming to page number. Annexure A3, which is at starts from
It's 35.
page number 35. My lord may kindly observe here also, although this second appeal was not maintainable, but here also, my lord may kindly see the third paragraph. Before filing the second appeal also, there was a delay of 177 days. Third paragraph, may I read? The present IA, this is the order dated 9/9/2025. This Kabang appeal. Annexure A3 dated 9/9/2025, this order. The third paragraph, after nobody appears for respondent, so and so, the present IA has been filed under section 5 of the Limitation Act 1963 for condoning the delay of 177 days in filing the second appeal registered at Pasighat, so such and such number. Although here,
the application was taken for the delay. However, it was found out that this is a wrong forum and not maintainable. For the sake of argument, had this forum has been a rightful forum also, there was still a delay of 177 days. And more so, my lord is aware that condonation petition cannot be just for the sake of equity, cannot be condoned on equitable grounds. The petitioner has raised that the applicant is a octogenarian, that 80 plus years old. But he has always been represented by a power of attorney holder. Even this application, my lord, may kindly see the affidavit part. He has a power of attorney holder who is a young man. So those grounds cannot sustain the Limitation Act, which it has to be Section 5, under Section 5. It cannot be condoned just on the basis of an equitable grounds. On that note, I have some judgments to be placed with, just 3 judgments, small paragraphs. This, may I first read, this one is 1997, 7 SCC 556. This is P.K. Ramachandran versus State of Kerala, the first one.
Yes.
This judgment has been referred in several other judgments, but my lord, paragraph 3 to 6 is important. May I read from, may I read just the para 6, the last line? Law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when the statutes so prescribe, and the courts have not power to extend the period of limitation on equitable grounds. The discretion exercised by the High Court was thus neither proper nor judicious. The order condoning the delay cannot be sustained. This appeal therefore succeeds and the impugned order is set aside. This is where the fact was where the government has filed an appeal. After the reason they have given is that Office of the Advocate General is always busy, so we could not file the appeal in time. So lately this judgment arrived. Thereafter, this has been referred in the other 2 judgments also. My lord, for the sake of brevity, I will just mention the para numbers. Para 6 and 7 is relevant in my case. The other judgment is, my lord, I will just quote 2021 18 SCC 384. Majji Sanema versus Reddy Sridevi and others. Here I rely on paragraph 6 and 7. Thereafter, the other judgment, third judgment I place is 2010 8 SCC 685. Balwant Singh versus Jagdish Singh and others. Here I rely on para 6 to 9 and para 13. The first judgment I will rely this P.K. Ramachandran has been referred in both this judgment. The basic contention in all this judgment that law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when statutes so prescribe. Courts have no power to extend period limitation on equitable grounds. So, my lord, equity is on the other side and technicality. The 490 days subtracted by the amount of time spent in the courts. Thereafter also, the petitioner at paragraph 6 himself has admitted there's another delay of 57 days. But nowhere in this whole application there's a whisper of what is the sufficient cause of those 57 days of delay. So that's all my submission, my lord. I want to conclude that more so, my lord, now coming back, just the brief background. I will not go into the merit, just for the understanding of this whole matter. Respondent number 1, I am for respondent number 2. Respondent number 1 is the seller of a plot of land in 4 puras. In Assamese is 4 puras, but in square meter it is around 30,000 square meters. So respondent has claimed through this kabang. 1988, I purchased the land from respondent number 1. 2019, he comes up with a kabang and says that my plot of land is 1,70,000 square meters. There I have like 25 to 30 square meters. So that first kabang was in my favor. Thereafter, even though there is no provision of second kabang, he again called up a kabang in the meantime, the second kabang, there also it went into my favor. Thereafter, my lord, I just remembered a fact. The petitioner has also not come with clean hands before this court. He has suppressed a material fact. After those two kabangs, when he filed an appeal before the DC, he simultaneously also filed a title suit which is still pending till date. Title suit number 8 of 2019. He has not come with clean hands. He's just trying to revive a lost cause through a CRP to decide his title, whereas a title suit 8 of 2019 is pending in Pasigat District Court. In where, my lord, may kindly record this also, where same prayer, same set of parties. Now the question is, even if the condonation is there, whether the CRP will be maintainable or not. This is just a harassment petition year after year. When in all these forums, the petitioner has not got any relief. After the two kabangs, appeal was dismissed. Thereafter, review was dismissed. Then went to the second appeal, which is a wrong forum. There was no provision of such. So not only he has failed to demonstrate the sufficient cause of the delays, but he has not come with clean hands before this honorable court. So my lord, on these submissions, may decide whether this application can be condoned or not. That's all my submission, my lord. In the title suit 8 of 2019, same party, same cause of, same prayer.
Title suit is 8 of
2019 with pending, still pending. And all this, the questions raised in the CRPs are disputed question of facts. And revision has a very limited area, whether there's an error apparent on the face of the record or law. So he's actually trying, in the garb of civil revision petition, he's trying to revive the decision passed in the appeal. Although he has lost in the review also, review petition.
I mean, there is a title suit, but not for the same subject matter. This particular, if Honorable Court can just come to the list of dates and events in the main CRP. I just, since it was not the CRP, I didn't want it to open that portion, but in the main CRP, they are just submitting that it was a Kaba decision of 2019. Actually, Your Honor, there was a Kaba decision of 2000, which was in my favor. After 19 days, 19 years, they have come with a 1988 sale deed without, in a simple plain paper. Simple plain paper, Your Honor. So this
say now say okay, I can understand. These are all
that
the
will be in
question
the
of
merit of
matter.
the
That's in the merit of the case. But
We
because
only
they are
dealing
submitting,
with why it wasn't 490 days delay.
Your Honor.
So as per your submission, you basically stress on the section 14, that is, it was a wrong forum.
Your Honor.
Now he is submitting that there may
Ignorance
be a
of
wrong
law.
forum, but even in the wrong forum also, there was a delay of 177 days.
Your Honor, that
And say 57 days delay is not at all explained by you.
yes.
That is the.
Your Honor, it is explained, Your Honor. It is explained, Your Honor. In para number 6 of page 5, Your Honor. This 490 days, Your Honor. I have not come with a superficial number, Your Honor. This is exact to the date that I've calculated. Thereafter only I come to 490 days, Your Honor. This is not a made up date that I made. They've just written it down in a plain paper.
Now in para 7, you have written that upon
Rightly
the
observed, my lord.
execution of the aforesaid periods,
Yes.
the net delay is only 57 days,
Your
which
Honor,
is neither intentional nor deliberate,
Your Honor.
but caused by bona fide reasons and continuous
Yes,
prosecution and remedies.
exactly.
That means,
This 57 days, Your Honor.
Ah.
This 57 days is also included in 490 days. But this particular 57 day is, Your Honor, when I filed the review, the impugn order that I'm challenging is passed on 11/6/2024. So as per section 9 of Limitation Act, it never stops. it is always continuous. So, Your Honor, I have filed it on 3rd 07/2024. That is after, as per review, 30 days is there. As per review, you have to file in the same court within 30 days. That's the law. But as per Section 9, for the sake of CRP, the limitation never stops. It always runs. So accordingly, Your Honor, the review petition
Always
was,
runs from where?
you know, 11, I'm calculating from 11/6/2024, the date of the order, the
Yeah.
date on which the order was passed, which I'm challenging. So accordingly, to file a review petition, I took near about 20, 30,
188 days.
Your Honor. Near about 28 days, Your Honor, in this particular, to file the review, Your Honor. To file the review, Your Honor. The review was filed within limitation, that is 30 days, but it was filed on 3rd July, Your Honor. That is within limitation, Your Honor, of review, 30 days. So this 57 days, Your Honor, and again, the second appeal was also filed on 4/2/2025, which was again decided on 7/1/2025, Your Honor. It is not possible to, if an order is passed, it is not possible to prepare an appeal or prepare a review within a single day. So I took 27 days, Your Honor, to prepare the second appeal, Your Honor. So it is all included in this 490 days. That is, if we can come down to recalculation effective delays, number A, Your Honor, total elapsed is, I'm counting from 11/6/2024 as per Section 9, Your Honor. Because to get the CRP admitted, Your Honor, I have to explain from 11 itself. So accordingly, Your Honor, I have calculated from 11/6/24 to the filing of the CRP. That is 14. I executed the petition on 12, but it was sent to filing on the High Court in 14. But on 14, the puja break was there, Your Honor. Accordingly, a notification was also issued by registrar on dated 15 September 2020, whereby it was said that working days of 3rd October to 17 October, Your Honor. It has been said that limitation will not run during the vacations. This was the petition was sent on 14, but it was ultimately filed on 17. The court was closed at that time. If I can just show the copy of the notification issued by this honorable registry in the year 2025, Your Honor. In the bottom, it is said that limitation will not run during the vacations. So I've been practicing out there, Your Honor. I had sent it for filing, but it was ultimately filed on 17 itself, Your Honor. So I am even seeking discretion in this particular point also, Your Honor. So I have only, during the drafting, I've only calculated it 14/10/2025. That is 490 days, Your Honor. I'm explaining every single day, Your Honor, from 11/6/2024, Your Honor. First being time during the pendency of the review petition, filing. Second being the time during wrong appeal, Your Honor. 4/2/2025 till 9/9/2025. But on this particular day, although the order says that it was passed on 9/9/2025, but it was kept for CAB, Your Honor. It was reserved, Your Honor. And the certified copy only was available to me on 7/10/2025, Your Honor. So accordingly, 28 days of delay is there also, Your Honor. So I'm calculating all those days, Your Honor. 188 days, 217 days, 28 days. Accordingly, Your Honor, pendency is 433 days. And So this 57 days, Your Honor, it is included in 490 days. Your Honor. एक घटिया घट
Hard, Mr. You, Mr. G. Talon?
My lord, can all this pleading which are not in the application, can it be taken on record? That is also my objection then.
What kind of?
The pleading that, the further pleadings, those are not part of the application. This, all
No,
this
he is not-
justification, all this given, because he is not justified. It has to be inside the pleading,
It's not there.
not there in the application.
No, it is there.
The justification you have made is not there.
It is there, Your Honor.
No, not,
He
not
he
in
is
the,
basically stretching on para 6.
yes.
Your Honor.
Para 6
Para
is
six
his
is-
only, para wherein
He has made a
stated
table.
that he is a table form is there.
Yes, my lord.
Acha, you are saying that the submission which has been made by.
Yeah, now only he is improving his submissions. But in the application, it's a small application of just 6 pages where these details of justification are not there. Can it be taken on record? Or moreover, the notification is now saying that High Court notification, these are not been annexed. On the spot, he is just placing it.
These are public records, Your Honor.
Be that as it may, my lord, he has not specifically submitted in his application. Para 7 itself says, I have the delay. My lord has correctly observed.
At the time of
57 days, now he's saying 31 days. Can it be taken on record?
At the time of filing,
He
only
has admitted in the
came to know
application.
about this notification, Your Honor.
Para 7,
Already.
my lord has
admitted-
rightly observed. He cannot improve now at this later stages. Once this application is filed, is on the record.
I am not improving, Your Honor. Lady, I am not improving, Your Honor. In this particular case, this is completely mentioned in para number 6, whatever I have stated here.
Yes.
Para number 6 and in the table, Your Honor.
And the next para 7?
Even in the prayer also, Your Honor, prayer section also, I've completely mentioned it. The discussion might be 432
Para 7 also
days.
57 days is written. Oh, I mean the prayer portion.
No, 433 days plus 57 days.
Yeah.
In the prayer portion.
My lord, I
You
reiterate.
can, how can you exclude the 433 days?
No, I'm not excluding that, Your Honor.
No,
I'm not
in
excluding.
para A, you're saying that condoned delay of approximately 57 days. After exclusion of 433 days.
Your Honor.
So how 433 days?
Your
There
Honor,
may be some exclusion if it is some certificate copies are there or the otherwise.
Your Honor, condonation of delay approximately 57 days after exclusion of 430 days of bona fide prosecution.
So then in cost title, you are saying 490 days delay. So what is your delay in fact?
490 days, Your Honor,
Then-
totaling, Your Honor.
Then you're in para, your prayer portion, you're saying that 57 days delay. You automatically, you yourself
No, no,
excluded the delay of 433 days.
Your Honor, it might be,
Now you
might be
see,
wrong
on
of me
your
to
cost
calculate
title,
myself,
in your cost title, it is declared that 490 days delay is there.
Your Honor.
And you try to explain
Your Honor.
through your tabulation and all.
Your Honor.
Now again, you are saying in prayer portion that there is only 57 days delay.
No,
You see, 57 days after exclusion, how after exclusion means?
Your Honor, it might be,
It will be excluded or your prayer may be there that discarded can be excluded.
Your Honor.
But you are saying that only 57 days delay, as per you only 57 days delay. In your troops, such a long delay in your filing petition in different forum, review, second appeal, first appeal, whatever, maybe in
Your-
wrong forum.
Your Honor. Your Honor,
Then
I
what
think
is your plea? Then 57 or 490?
Your Honor,
It's quite
490
confusing.
490 days, Your Honor.
Then your prayer doesn't support you. It is only 57 days delay. We have to delay the condom for 57 days only. There's no mention about 490 days delay.
Your Honor,
Tabulation calculation is okay. You have submitted that even if suppose calculation 430 days excluded wrong forum, everything. Now 57 days, you did not make such an explanation, only 15 days, para number 7, you made one line is there.
Your Honor.
Even if it is considered suppose one line. In that case also your prayer doesn't, you see your petition first, you see if you can do one thing
Your Honor, it
by 490 days, again 57 days. So we have to pass the order na, on 57 or 490.
Your Honor,
There will be one category, na?
Your Honor, I was actually drafting it for 490 days, but since 57 days was written here, Your Honor.
You
it
can
should have been
explain your
490.
entire 490 in tabulation form, it's okay.
Your Honor.
But you are excluding yourself, 433 days you have excluded by yourself. Then you are saying that means delay is only for 57 days, as per you. As per you.
But then
Now 490, you are saying 490, calculation is there for 490, it's okay, 490 is there. Then you excluded something, 433 days and 57 days you have calculated. Now in the prayer portion, you say they only to delay the condon of 57 days. See, you see,
I've seen, Your Honor. It might be, Your
make
Honor.
some correction otherwise. How can we entertain now? That is a confusing thing. Your prayer, if so, your prayer is allowed, then your entire petition will go otherwise.
Your Honor.
Or only for 57 days if it is allowed, suppose.
Your Honor.
So try to make some clarification on that point, or you may file an additional affidavit to that regard for correction of your prayer portion. Make some correction.
Your Honor, if it might have been some error from my part, Your Honor. I think that's the thing, Your Honor. But I had intended for 433 days for the time during the pendency and 57 days during the time to file this.
Okay, I can understand. So 57 delay, you have also explained in your para 7.
Your
I have seen. Now what your prayer says, only 57 days.
Your Honor.
We cannot pass the order on 57 days. We have to pass the order again on entire 490 days,
490.
whatever, but maybe.
Your Honor.
So you made some explanation why a wrong forum and all these are there.
Your Honor.
But as you, Mr. Izis pointed out,
Yes.
so in 177 days delay was there in second appeal also. It
Your Honor.
seems.
Your Honor.
It is not a case that here only it is a 490 days delay. In second appeal, rightly, wrongly, whatever.
Your Honor.
In filing the second appeal also there is 177 days delay. So that is there.
Your Honor.
Isn't it? So 177 day, you are now calculating 177 along with 128, 138, and everything is calculated in 490.
Yeah.
But still, I'm considering 490. But again, prayer is 50. There will be a problem for us.
More so, my lord, in the CRP also, all are questions of disputed, and I've already brought the attention that there's a title suit pending, which trial court would be the right forum to decide whose title the land is.
So title suit is still pending.
That also has not been brought to the knowledge of this honorable court.
It's not with respect to this Porpura.
No, it is on the same, the entire area in which my land also comes.
No, Your
He is claiming a whole area where I have only 4 pura.
Your Honor, if I may.
So it's there in the title
If
suit.
your title suit includes the land of the respondent also, then
I am party
your
there.
purpose will serve, I think, if the title suit is there.
Your Honor.
Correctly, man.
Because title suit now from the entire evidence it has come, the title suit is the best forum, or the civil forum is the best forum.
Your Honor. Your Honor, this particular CRP.
So one thing then,
Kava is only with respect to.
you have already, because I'm for 4 or 5 days here, so I cannot give you such a time for this one. You do one thing, it'll be not good. আচ্ছা আচ্ছা এইটো ইয়াৰ লগত একেলগে থৈ দিব এইটো এটা খেদাই দিয়া আচ্ছা আচ্ছা সেইটো বাৰু মই এতিয়া নকৰো আৰু উপায়টো নাই make some amendment in your, especially in your prayer portion. Otherwise, it will again affect you because 57 prayer we cannot allow now at this stage. Obviously, you've got some reasonings. I don't disagree with you. You have problem. But he also submitted in that manner in second appeal also there is 177 days delay.
Man, the order may be reserved.
No, we are not going to reserve the order. We are directing you to file an additional affidavit for correction of your prayer portion. Immediately.
Okay.
Within 2-3 days, by next week, it may be listed.
Okay.
It may be listed in the next week also. By that time, you make your correction, file an additional affidavit for your correction. Otherwise, it will again create problem. If 57 is allowed, your prayer is allowed, then it will again create problem. Okay. So that's why I thought that better to make some correction in your prayer portion itself. Which one I will be able to hear it? Given number 17. Na?
17.
Oh, 18. Heard
18.
Mr. Gitalo, the learned counsel for the petitioner.
His 8th talo, man.
8 talo, no?
Your Honor.
Oh, sorry. 8 talo, the learned counsel for the petitioner, and I also heard your Mr. Jammo, na?
HK Jamo, my lord.
HK Jammo, the learned counsel for the respondent. After hearing the petition at a length, it is seen that some corrections of the amendment is required in the prayer portion of the petition itself. In view of this, the petitioner is at liberty to file the corrected or the amended prayer portion through an additional affidavit. And after correction of the prayer portion, the matter may be heard and decided accordingly. This matter, সপ্তাহের ভিতর date দিয়কচোন। not 9, 10, 8, 9, 10 will do.
15 Lordship.
15 because 8 are already fixed. I think.
It will be on 12, Your Honor.
12 to 10.
It's Friday.
12 is Friday. Don't make it on 12.
Yes. Can you fix on 15th?
15th.
It's a Monday. 1-5.
1-5.
Yeah.
Okay, then 1-5. List on 1-5. 1-5 so enabling the petitioner side to make the necessary arrangement to file the amended or the corrected prayer portion through an additional affidavit. Okay.
Oblige.
Make it clear.
Oblige.
Item number 11, passport matter.
It we had a third and item number. Oh, you have come.
Yes, my lord. My lord, this is the judgment rendered by the my lord coordinate bench. My lord.
Okay. So basically, you're pointing that the 35(3) cannot be issued
Yes, my lord. Neither
without registration. Or
yes,
what?
neither 35(3) nor someone under 179, my lord.
No, 179. He has not issued 179.
My lord, as per the status report, my lord, status report, what status report says that initially it was issued under section 35(3) by mistake.
Oh, so by mistake.
Yes, my lord. Now it may be construed as 179. So, my lord, I've come across, my lord, the judgments are there, that judgment rendered by our own coordinate bench. There we specifically dealt with, my lord, section 179, that is for summon. My lord, on 35 also I have judgment, my lord. I will place it, my lord. Here, my lord, in this judgment, my lord, may kindly come to para 14, my lord. May I read, my lord, operating, my lord,
yes.
N number of judgment has been, my lord, referred both by us, the prosecution side, as by the petitioner side also, my lord. And then, my lord, the court has come to the conclusion that in the aforesaid judgment, it has been amply made clear.
Which para you are reading? Just a second. Which para?
Para 14, my lord, last page.
Achha, yes.
May I read, my lord? In the aforesaid judgment, it has been amply made clear and held that a summon under section 179 of BNSS cannot be issued without registration of an FIR. In the present case, admittedly, no FIR has been registered against the petitioner. Therefore, the impugned summon notice under section 179 of BNSS has been issued in absence of any lawful investigation. The action of the police is therefore without jurisdiction and contrary to the statutory mandate. Such exercise of power result in unwarranted harassment of a citizen. Now, at 17, my lord, here, the court has further directed, my lord, considering that despite repeated judicial pronouncements, such as summon notice are being routinely issued by the police without registration of an FIR, this court deemed it appropriate to issue the following direction. My lord, the DGP was directed to instruct all the police. The investigation officer shall be sensitized the issue of such summon notice without registration of FIR is illegal and impermissible. It shall be ensured that appropriate this part, my lord. Now, the copy of orders have circulated to so and so, my lord, because many cases will come up, my lord, wherein without registration of FIR 179, my lord, someone was issued. In fact, my lord, we have even appreciated the provision of the chapter of the investigation, my lord, from 154, that earlier corresponding section. For the investigation, for the purpose of investigation, my lord, there is nothing section empower the police to register any FIR before investigation, my lord. The investigation come into effect when FIR is registered, my lord. So, my lord, and so far as, my lord, I have relied, my lord, the copy of the judgment, my lord, I have given the citation, my lord. My lord, may kindly come to Lalita Kumari judgment, my lord. Basing on, my lord, that guideline only, my lord, in certain offenses, my lord, the police has to make preliminary inquiry before registration. So now, my lord, so far as the Lalita Kumari judgment is concerned, my lord, the guiding principle is laid down in para 120, my lord. This is reported in 2014 to SCC case 1, page number 1. Now, my lord, we'll find guideline is laid down in para 120, my lord. And in 120, my lord, I would rely 120.5, my lord.
120.5,
my lord.
Yes.
May I read, my lord? The scope of preliminary inquiry, my lord. Here, my lord, through judicial inroad, my lord, the preliminary inquiry was brought down by the Supreme Honorable FX Court because CRPC as well as BNSS is still silent about, my lord, preliminary inquiry, my lord. It was judicial inroad, my lord, through judicial inroad, the preliminary inquiry, my lord. May I read? The scope of preliminary inquiry is not to verify the veracity or otherwise of the information received, but only to ascertain whether the information reveals any cognizable offense, my lord. So it's very limit, my lord. So it can be, my lord, find out from the content itself, my lord, that whether it disclosed cognizable offense or not. And in my humble understanding, my lord, it is the complainant who has to make a complaint which should attract cognizable offense. So, my lord, at the preliminary inquiry stage, what at most the police can do is, they can, no doubt, my lord, although the court does not provide, they can make an inquiry by themselves, my lord, because basing on the material on record, my lord, for illustration, my lord, in some cases like 420 cases, my lord, cheating and all, certain documents are being annexed and produced by the complainant, my lord. So to find out whether the documents which they have produced is the genuine one or is the forged one against which the allegation has been made, that can be cross-verified from the concerned authority, my lord. So what, my lord, the preliminary inquiry is there is very limited scope, only to find out my lord, whether the information reveal cognizable offense, not the veracity, my lord. If Supreme Court has held that the police can find out the veracity also, then, my lord, this power could have been extended, my lord. Because otherwise, my lord, if FIR is not registered, the person proposed accused cannot be termed as an accused, my lord. He is a proposed accused, my lord. Only after registration of FIR, he become an alleged accused, my lord. So on that context, my lord, it was held that yes, 179 can be exercised only when investigation can be carried out, and investigation initiated as and when, my lord, FIR is registered pertains to cognizable offense, my lord. Not with the non-cognizable offense. And now, my lord, in this present case, initially 35(3) was issued, my lord. So now, my lord, if we see section 35, my lord, now 35 is the corresponding of, my lord, section 41A of the judgment, my lord. Now, the Supreme Court has dealt the 41A in Ernest Kumar, my lord, matter. Now, I'm relying Ernest Kumar matter. Then I will come to, my lord, the Supreme High Court judgments also, my lord. Here, the Ernest Kumar judgment, my lord, is reported in 14(8) SCC 273, my lord, paragraph 10, my lord.
Yes.
Para 10, my lord, it says, we are of the opinion that if the provision of section 41 CRPC, which authorized the police officer to arrest an accused without an order from a magistrate and without a warrant are scrupulously enforced, the wrong committed by the police officers intentionally or unwittingly would be reversed, and the number of cases which come to the court for grant of anticipatory bail will substantially reduce. We would like to emphasize that the practice of mechanical reproducing in the case diary all or most of the reason contained in section 41 CRPC for effecting the arrest be discouraged and discontinued. Now, my lord, the 41A is the, my lord, exception to 41, my lord. It's 41A says in the cases where the arrest is not required. And, my lord, that the investigation authority can draw an inference as and when, my lord, the FIR is registered
and he has to decide, yes, whether this accused is required to be required, his custody interrogation is required or not. He has to decide first, and he has to maintain a checklist. If arrest is required, he has to note down in the checklist why the reason of arrest, and if he is arrested, he has to be produced before the magistrate, my lord. But if to the general, my lord, exception to the 41, that 41A, here, my lord, it says when, my lord, the it's not required, arrest is not required. It's provided in, my lord, 11.6, my lord. 11.6 says, notice of appearance in term of section 41A, corresponding 35.3, my lord, CRPC be served on the accused within 2 weeks, my lord, now it says, from the date of institution of the case, which may be extended by the SP of the district for reason to be recorded in writing. Now, here in clear term also, Supreme Court says, it must be, it should be, my lord, issued in, if the arrest is not required, within 2 weeks from the date of institution of case. Now, my lord, institution of case is when the FIR is registered, my lord. If FIR is not registered, my lord, they cannot be considered, the police cannot investigate the matter, my lord. They can make a preliminary inquiry only to find out whether it disclosed cognizable or non-cognizable. If non-cognizable, they will simply make GD entry, and, my lord, may inform the complainant to approach the magistrate, or they have other records also. But, my lord, for cognizable offense, my lord, they have to register the FIR, my lord. Now, my lord, here, some judgments of the, my lord, High Court is stretching on that aspect. From Madras bench, my lord, Madras High Court, my lord. Bimal Chinnappan versus State of Tamil Nadu, my lord. Para 5 and 6, my lord. May I read, my lord? Para, my lord, this 5 onward. It is seen from the notice sent by the second respondent that he has sought response to about 12 questions from the petitioner, primarily relating to the publication of the article containing defamatory allegation against the police. Admittedly, the notice has not been issued in connection with crime so and so, as the investigation therein has already been concluded. If the petitioner was required for inquiry in any other case, inquiry, my here, the respondent ought to have referred to the crime number of such case. Admittedly, no other case has been registered against petitioner. 6. That apart, section 35(1)(b) of BNSS only specify the circumstances under the police officer may arrest a person without a warrant, and does not empower the respondent to summon or question the petitioner in absence of any case registered against him. Therefore, this court is inclined to quash the impugn notice. However, it is needless to state that if any case is registered against the petitioner and his presence is required for inquiry in such case, this order shall not stand in the way of the petitioner in accordance with. But here also, my lord, in this case, my lord, the notice was issued prior to the registration of FIR, and basing on that, my lord, the matter was quashed, my lord. And well, interestingly, in the present case, my lord, although I have been telephonically instructed, no case has been registered, and perhaps, my lord, it was found to be non-cognizable offense. So FIR was not registered, and my lord only made the GD entry, and the complainant has already been informed by the investigation authority, my lord.
But is there any status report also says so?
My lord, status report, my lord, so far as the status report is concerned, my lord, it was received on March. So on March, when it was received, the IO inquiry officer has only, my lord, stated that the notice under section 35(3) was mistakenly placed, and in 35(3) it may be read as 179 BNSS. Now, my lord, I have contacted the concerned, my lord, SDPO. They've informed us that indeed the FIR disclosed non-cognizable the offense, so they have closed the matter. But now it is not in written. So, my lord, if my lord is disposing inclined to dispose of matter, call for the status report, my lord, because it was just a communication, telephone communication to the concerned SDPO, my lord. If we receive in written, my lord, that will be more, my lord, appropriate, my lord, to close the matter, because once it is, my lord, the FIR is not registered, and if it's and the matter has been only found to be non-cognizable one,
then the matter does not survive, man. It goes, man.
Survive at all, yes. So now what is your case? Whether the police officer is still harassing you or telephonically asked to come? At present, there is nothing. But coming to know about that things, have you ever tried to appear before the, not under 35, just I'm saying, for any, your cooperation is whether needed and all, whether you have appeared before police station? Pardon?
I have not been called by the police officer.
And my lord,
You have only received 35-3. You have only received the 35-3.
Only this notice of appearance.
No, whatever.
There was a subsequent notice which was caused by the Honorable Court. Because also not maintainable.
my lord, will find the judgment which I have, my lord, referred of the coordinate bench. In that case, the notice was quashed by the coordinate bench against him only, my lord. Even in that case, the notice was issued against him, my lord.
Oh.
And my lord, the core issue is actually, my lord, the group of people is alleging him that he has obtained a fake ST certificate. So now, so far as my understanding is concerned, my lord, as per the Madhuri Rani Patel, my lord, the matter has to be placed before the scrutiny committee, my lord. Investigation authority got nothing to do at this stage, my lord. Unless, my lord, anything comes up. So, my lord, in any case,
Any report of scrutiny committee is not.
no, not there, my lord. Even my lord, it's not on the record, but my lord, even they are not sure whether he has obtained ST certificate or not. It's just an allegation. They are not saying he is possessing, but they are just, my lord, alleging that he may have taken benefit of the ST quota.
ST quota.
Yes.
Then let the matter be finally disposed of. Status be maybe called for present status.
Yes, ma'am.
If the status is there that there is no cognizable offense is there,
Yes, ma'am.
then definitely matter would end up in that manner.
Yes, ma'am.
And as per your information,
Yes,
they
ma'am.
have most probably informed the complainant also.
Yes, they have informed the complainant, and the FIR does not disclose cognizable offense, ma'am.
It is command number, item number 11.
Yes, ma'am.
Yes. Heard Mr. Ibam, the learned counsel for the petition, also heard Mr. T. Ete, the learned additional PP, appearing on behalf of state respondent. The status, in pursuant to the order dated 19/02/2026, the status report is already received from the investigating officer, but it is submitted by Mr. Ete that the report pertains to, report is of March 2026.
5 March 2026.
5th
March.
5th March 2026, and the present status is not available, full stop. It is basically case of the petitioner that the notice which was issued by the investigating authority under section 35(3) BNSS is not at all maintainable without registration of a case, and till that there is no registration of the case as per instruction of the present petitioner. In that context, it is also submitted by Mr. Ete, the learned additional PP, that it is a fact that the case is not yet registered, and only on the basis of the GD entry, the notice was issued. However, as per the status report, it was issued mistakenly by the investigating officer, and it can be considered or termed as a summon under section 179 of BNSS. However, Mr. Ete cited some decisions and may place some argument that in that event also 179, summon under section 179 is also not maintainable without registration of a case. That apart, it is submitted by Mr. Ete that there is, as per submitted that as per so far information received from the IO, the case may turn to a non-cog offense, and hence is submitted that the present status will be required in that context. Next para. In view of this, later present status be called for from the investigation. Police are in charge, officer in charge, which is police station?
Itanagar PS.
Officer in charge, Itanagar Police Station, regarding the present status of the case, which is not registered, is entered as GD entry number 18/2026, dated 11/02/2026. Let the status report be accordingly called for, and matter may be finally heard and disposed of on the receipt of the status report. When it can be?
But the fixed date can be given, my lord. It won't take much time, my lord, because it's from Ita.
On third, Lordship?
Third, I don't hearing what I say.
Fourth, my lord. Maybe fourth or fifth. Fourth, fifth.
Fourth.
Fourth, okay. Oblige.
In keeping your these things, we are keeping.
Yes, ma'am. Yes. Oblige.
Item number 20.
এইটো এটা হেৰি উলিয়াই থাকোতে ললিতা কুমাৰী আমাৰ কিতাপ নে কাৰ কিতাপ আমাৰ লাইব্ৰেৰী আছে এইটো কিমান দিলে ফৰ্থত দিলে ন এইটো ফৰ্থ নেকি item number 20. Yes, what is it?
Sustaining the conviction made by the Lalit Bhutia, which was subsequently affirmed by the Lalit District and Session Bhutia.
No, why it is an order call?
I file was submission of delay of 312 days. Starting this revision.
We'll issue notice in that case.
Yes.
It is the conviction was upheld by the appellate court.
Yes.
Okay, under which section? It is a case of negotiable.
138.
Negotiable articles. So basically, the state may be a formal party, I think. State is not yet party also, no? State not required. No, not required. Sometimes it state is maybe a formal party, but here you have not required.
No.
Okay, hard Mr. Ibam, the Learned Counsel for the petitioner. This is an application under Section 5 of the Limitation Act for condoning delay of 12 days in filing the connected criminal revision petition against the impugned judgment and order dated 22/04/2025, passed by the Learned Session Judge, Capital Complex, UPA, Papumpara District, affirming the conviction and sentence dated 30/03/2023. Post of issue notice to the respondent through speed post and usual process. List 2 weeks minimum will be required, I think. List the matter accordingly after 2 weeks as on a date to be fixed by the registry.
Item number 21.
Now see, we are in mediation drive.
Yeah. My lord.
There is a nationwide mediation drive is there, so we are, so in that context, we are identifying some of the matters for referendum. What we want to submit here?
My lord, I would like to withdraw my name as I was.
You want to withdraw your name?
Yes.
Acha.
Because for personal ground, I don't want to be in this mega field. So my name will be spiked out and other.
Apart from you, there are other 2 councils are there.
Yes, they will remain, my lord. They will remain as an advocate. My name may be spiked out.
So regarding the sending the matter to mediation, you will not be able to say anything now.
I won't be able to say because in the earlier occasion also I.
See Modi ahana nahi.
Right.
You are for the respondent.
Yes, madam.
So what is your say? If matter can be sent?
Yes, my lord, it can be sent. We are just discussing with the insurance company that they are also interested to settle because of this case is only shifting the liability to owner to driver. As policy was valid, driving license was valid, and premium for the conductor is also taken, even though the judgment was passed against the owner. So we have no objection.
But now we are not in a position.
I'll inform Mr. C. Modi.
Machiavelli of 2025, no? So we could have tried to sending it mediation, but if you have some problem, I want to say yes, item number 21. Heard Mr. U. Deka, the learned counsel for the appellant, and also heard Mr. B.R. Das, the learned counsel appealing for the, you are appealing for the insurance, no?
No, my lord, I am respondent
Private
number two.
respondent.
Respondent number 2.
So for the private respondent?
Yes, my lord. He is the claimant here.
Acha, claimant respondent, full stop. This case was identified for referral to the mediation, but it is submitted by Mr. Deka that Deka, the counsel for the appellant, that he is not in a position to say anything as he wants to withdraw his name from the case, though the other two counsel will remain as a counsel for the appellant. In a view of this, কি কৰিব এই শ্ৰীমতীটো নাই নহয় So can you inform the other side?
Yes, I can inform because he is my associate here on
Acha.
the lordship. He is
However,
my-
it is submitted by Mr. Deka that the necessary information will be provided to the other two councils in this regard. Mr. B.R. Das, the learned counsel appearing for the claimant respondent, however, raised no objection and submitted that the party respondent is has no objection if the matter is sent for mediation. Next para, in view of this, let the matter be accordingly listed. After 1 week will do.
Yes.
You will be able to after
Yes.
1 week as on a date to be fixed by the registry. And
My name may be strike down, but
at the request made by learned counsel Mr. Deka, his name may be strike out from now. There are some procedure in fact, so you have entrusted with Pakaratnam, I think. So we cannot just allow you to withdraw this case. This is not our, you have to issue notice to the other side also.
okay,
In that case, na?
yes.
In fact, in that, accordingly, the Mr. Deka will also take necessary steps in issuing notice to the appellant authority. Appellant, appellant, full stop, to before withdrawing his name from Wakalatnama. Let the matter be accordingly listed after 1 week. Okay, then.
Yes, my lord.
Okay.
My lord, can the item number 25?
Yes? What?
Item number 25. I am appealing in this case, my lord.
Acha. Item number 25.
25. My lord,
Yes, government advocate is there. Why? Why government? Oh, chief secretary and others. And it's a government vehicle, I think, no?
yes, my lord.
This was a government vehicle.
That IA 35 is, my lord, there in respect of filing IA 276 of the 25. That, my lord, at the time of the filing, in para number 10 in 22, there is just mistakenly typographical mistake. That
In
deeply-
I, in I.
IA in 20.
So now the present I is your 35, 2026.
Yes, my lord. That's to be the allowing to correct the errors in the IA number 276. My lord, actual delay this is to 72 days, but in para number 10 and 20, it was wrongly stated as 95 and 90. So
Actual delay is 72 days.
72 days, my lord.
So it is only for correction.
Correction, my lord.
Correction of your IA 276.
276. The actual delay of 72 days. my lord.
Acha.
That's all.
Heard Mr. B.R. Das, learned counsel appearing for the applicant appellant. Non-appearance call for the government side, government advocate. This is an 35 too, huh? This is an application
25.
for, yes, yes, 35 or 25, 35.
Oh, yes, IA number 35.
Yeah, this application is filed for correction of the modification of the order dated, which one is order dated?
Order dated, my lord,
So in order was also there,
yes,
26.
there are the order to correct the first fatal case of the mistaken
Typographical mistake in para number 10 and 22. Yes.
So order was passed on 26.
Yes, 26, 11, 25. madam.
Twenty-six, 11.
2025. In IA number 276 of 25.
So what is the now this? 276 is not disposed of. Here you have made a prayer
Yes, my lord. In
to file a appropriate application.
Yes, my.
So modification of 2611 is not required. Correction and modification you have written, no? Modification of the IA criminal, also IA civil, number 276 of 2025, filed under section 5 of the Limitation Act, read with section 151 CAPC, where is prayer for condonation of 72 days delay in respect of filing the connected MSc appeal was made. But inadvertently, there was some typographical mistake. And in pursuant to order dated 26/11/2025, the present application has been filed for amendment oblique correction of some typographical mistake in IA Civil 276 AP of 2025. Full stop. Next, where it is submitted by Mr. Das that inadvertently. So what is your case? Is it is written as 90.
90 and para number 10 and 20, para number 22 in IA number 270, there is mentioned as 90 days and 95 days. And in the prayer section in a constructed place, there is correctly mentioned as 70 days. So then the correct delay is 72 days and days mentioned in para number 10 and 22. This is wrong. Okay.
Cost title is also wrong.
No, cost title is correct, madam.
Cost title is correct.
There is correct, but in
Cost title and prayer is correct.
correct. But in para number 10 and 22, there is some typographical mistake. Delay, days of delay was mentioned as 90 days and 90.
Prayer is also okay. Para 10 and 11, no?
Yes. 10 and 22 months.
10 and
20. Para number 22 last line, para number 10 last line.
What you have written? Submitted. Last line. Acha. Full stop. Next para, it is submitted by Mr. Das that inadvertently in para number 10 and para number 22, the days of delay is mentioned in the last line. The days of delay is mentioned as 90 and 95 days respectively due to inadvertent typographical mistakes which needs to be corrected. Next para, considering the submission made by Learning Council for both sides. And this court is of opinion that the prayer for correction oblique amendment in para number 10 and 22 as stated above can be allowed for the ends of justice, and accordingly the petition is allowed. Now you're going to file a corrected one. That it can be. Accordingly the para number 10 and 22 will be read as, according to the last line of para 10 and 22 will be read as 72 days delay instead of 90 and 95 delays as referred above. Necessary registry will do the necessary corrections. The above observation, the present I stands disposed. And that you have issued notice also? Copy this. Okay. Please step up.
Item number 22.
Yes, 22, what is the position?
My lord, the matter is for mediation, but my lord, service is completed, but but no one appear on behalf of the private complainant, my lord.
What nature of case is it? Is it a compoundable or
No, my lord,
mediation can be?
My lord, it's about, my lord, cheating and all is there, my lord. On business transaction, my lord, arising out of business transaction. So if, my lord, the other side come, then the attempt can be made through mediation, but my lord, no one is appearing, although the service is completed, my lord.
Service is already complete.
Yes, my lord. As per the, my lord, the plague mark is there, my lord. The notice was served through concern, my lord, officer in charge, police station, Nirjuli, my lord. On 8/5/26, it was received, my lord.
Okay. Dear Mr. Ram, huh? T? Achha. You're saying T, Techi? What is
My lord,
Acha. Mr. T. Techi, the learned counsel appearing on behalf of Mr. N. Rama for the petitioner, and also heard Mr. T. Ete, the learned additional PP appearing on behalf of said respondent. The case was identified for sending it to mediation, but it is seen that in spite of receipt of summon, the private response number 2 is not appearing, and his presence will be required to send the matter for mediation. However, from the record and from the submission made by Mr. Ete, it is seen that notice was served on 8/5/2026, but no one has represented the respondent number 2. In view of this, the matter cannot be sent for mediation, and accordingly, the registry is hereby directed to list the matter in admission column after 1 week or 2 weeks.
2 weeks, madam.
After 2 weeks, as on a date to be fixed by the registry. So it will be listed for mediation, I mean admission column.
Admission, yeah. Obliged, ma'am.
Item number 23.
Neither. 23, none appears on call for the petitioner as well as respondent. List the matter after 2 weeks, as on a date to be fixed by the registry.
Item number 24.
Yes, you are for the,
I'm for the appellant here in this
Appellant.
case, yes.
for the respondent.
Yes, my lord.
So what do you
Your
suggest?
Lordship, if the respondent party, they agrees, then I don't have any objection for mediation.
Yes, my lord, settlement is, my lord, not possible then.
Why?
My lord, since the Honorable Trial Court has rightly passed an order for the compensation.
No, we are not on right or wrong. Mediation is a different subject.
My lord, as per
Go
the-
for the mediation, there may be, suppose if 5 lakhs, 6 lakhs is there, it may be say 7 lakhs, it may be reduced to 4 lakh or whatever. This kind of only. Right, wrong, we have mediation. The mediator has no authority to decide a case only whether it is right or wrong. That is not there.
Yes, my lord.
He's simply asking whether your petitioner is ready for mediation.
No,
There may be a discussion, a mediation will going on, the mediator in presence of mediator.
Yes, my lord.
That much only.
That is there, my lord, but my client has suggested me, my lord. Directed me that he is not ready to settle.
You have not, explained what is the function of mediation. In fact, that's why your client is not ready.
My lord.
Your client should be ready because it will be disposed of very quickly. It is up to the 2026 matter, isn't it? So if we go by this general process, I don't know, it may take some time. Take some time, maybe 6 months also, but if it goes for mediation, and there may be a probability of disposal of the matter within 1 or 2 months. So these are there.
Yes, yes, ma'am.
You will be benefited to some extent, the other party will also be benefited to some extent because you are the respondent, then they are the appellant.
Yes, my lord.
So if they agrees to some extent, that it will be benefited for you also. I don't know what is the position, I'm just saying.
Yes, my lord, that is there.
So do you want any further date for your party to be consulted, or you're saying that refusing that don't want?
No, my lord. In a regular court, my lord. I will file my reply, ma'am, on next.
A reply will come later on. Yes, you are Mr.
M. Kambo.
Heard Mr. M. Kambo, the Land Council for the appellant, and also heard Mr.
And UB, my lord.
and UB, the Learned Counsel for the respondent. Mr. Kambo, the Learned Counsel for the appellant, submitted that the appellant has no objection if the matter refers to mediation. However, it is submitted by Mr. UB that the respondent is not at all willing for matter to be sent for mediation. In view of this, let the matter be accordingly listed in due course of time. In which column it has to be listed?
In admission.
In order column, I think.
Yes.
Oh, it's order.
Yes.
It
They
will
have
be
to file
listed
reply.
in order column. Okay.
Right, ma'am.
Item number 27.
No hearing will be taken up. Sorry, I'm not going to take the hearing today because one more matter is there. I'm going to dictate the matter.
My lord,
It's already 3.
in this case, there's a issue of maintenance. So next examine things for issue on maintenance of the petition.
It is already fixed for maintainability issue or not yet?
Not yet.
Otherwise, it is fixed for hearing.
Hearing.
So you want to raise a maintainability issue
Yes,
also?
because well, they file again one IA. So before that, it is necessary to decide the maintainability of the case.
Maintainability, my lord, is already contested.
Maintainability issue is already been contested. Then?
In the
What is that?
affidavit in opposition, yes. This is all about maintainability only, the affidavit in opposition.
And regarding this
It's not-
civil division, because my
Yeah, civil division is
but
fixed for hearing.
they filed the civil division under 115 of the CPC against the interlocutory order. Because under 115 of the CPC.
So you are raising that point only. That is okay. you're saying that CRP may not be maintainable because it is against an interlocutory order.
Yes.
That is your main issue. So why not? It is not required that another maintainability issue has to be there. It will be come under the, if you hear the matter, then definitely your main contention will be this is not maintainable. 115 is not maintainable here because an interlocutor. That much your submission. On that regard, we'll hear you matter.
Madam, before coming to the merit of the case, so I am raising this issue.
No, obviously. Now, see, question is that when this CRP will be heard, suppose other side may submit on merit, but if you submit merit come maintainability, both will be considered. So, or you want to submit exclusively on merit or on maintainability,
Madam,
exclusively on maintainability,
Madam, problem is that in this case, TCR was not yet called.
not yet called.
Yes, if the case is hard on the merit, the TCR should be called for.
What this year is not called for. It's a hearing list listed for hearing. What?
Till the TCR was not called for.
Only Corona now this year.
Because madam, this application is not at all maintainable. Simple issues.
Oh, this year was not called.
Before that, if we decide the maintainability, and if it is maintainable, then we go for the further proceeding. Then for that, we need TCR.
My lord, in that case, fifth day after tomorrow, my lord, this may be listed for argument.
No, day after tomorrow, I have already fixed 3 matters most probably for hearing. It may not be possible.
Then
Thursday again, division DV is there. And Friday to you all know we are listing less numbers of matters. So maybe on next week. So what do you want to submit? If the matter, what Mr. Counsel for the other side is submitting, that if we want to dispose it on merit also, in that case, the TCR will be required as per his submission. And what is your submission? Suppose I think that maintainability issue may be raised and the merit can also be heard.
Yes.
Same time. So in that case, what do you want to submit?
My lord, this may be taken about 18, my lord.
1/8.
Yes, ma'am.
With the TCR or what?
So,
In that case, we are calling for the TCR also. We'll call for the TCR also.
there's a problem, my lord. In the trial court, this has been listed for final argument on 24th, my lord. So anything up if it is not disposed before 24th,
No, we are calling for a scan copy only.
Yes.
Not the TCR.
Not TCR.
And there will be no effect on. That's why I'm saying that why you want to fix it on 18. That will again create another problem. Let it be fixed on 8 or 9 of this month, no? Parujudi.
How much?
8 or 9 of
Yes.
this month. Then it will be the matter may be disposed of or whatever.
Yeah, no problem.
In that case, but I think that by 8 of this month, whether the TCR will be received by this court,
Yes.
it is from to where from? It has
From first rank district, Yingkiong.
Nahiwana.
So while if it is, I think this application is not maintainable. So first we have the maintainability of the case. Then if it is maintainable,
Agreed?
or for the TCR.
You are agreeing?
Otherwise, it is unnecessary for the court.
You are Mr.
Omodi.
Hart, Mr. Oh, sorry, Hart. You are Mr.
And Padam.
N. Yes. Hart, Mr. N. Pada, the learned counsel for the petitioner, and also Hart, Mr. Modi, the learned counsel for the respondent. The matter was listed for hearing, but it is seen that the scan copy of the TCR is not yet called for. However, it is submitted by Mr. Modi that the respondent side is basically raising on the issue of maintainability, and he submitted that maintainability issue may be heard maintainability may be issued on hard to stop. In view of this, let the matter be listed on human 8 position 9.
Not check. 8 is Monday.
8 is Monday.
Monday.
8/6/2026 for hearing on maintainability issue. In the meantime, the registry will also take necessary steps in calling the scanned copy of the TCR list according. Okay. Then.
Item number 29.
May I please, Your Lordship? This criminal
hear
appeal,
now.
Lordship. Am I audible, Lordship?
Yes, audible, but we are not going to hear the matter today.
Lordship.
Not going to hear the matter
Yes.
today. So,
In that case, Lordship, can it be after the vacation and vacation? Or in the third week of this month?
after vacation, we'll again, because your petitioner is in jail, I think.
Yes, Lordship.
Your
Yes,
petition is behind the bars. So, if after vacation, then it will be a long date.
Too
So,
long. Let it be in the
too
third
long.
week or fourth week, Lordship, of this month. Third week.
by month of June only, we are trying to accommodate you.
20
Can
Lordship,
it be in the
20
third week,
June,
Lordship?
so Wednesday Lordship.
20.
Lordship, may not fix any date. Let it come after third week, Lordship. Because Lordship, why I'm saying, Lordship, I am supposed to undergo one surgery. I am to be admitted in hospital on 8th. So after that, Lordship, I do not know how much time I will take to recover. If it is a fixed date,
For
it
eye
becomes
surgery?
difficult. No, Lordship, it's a
No, for eye surgery.
my own surgery, not eye surgery.
Eye sur-
So, stomach surgery.
Anyway, okay then.
So, Lordship, I will pray that no.
Then what do you
maybe
want to
fixed-
say? Third week of June?
Third week of June, Lordship, third and fourth week of June, before vacation, we'll do it, Lordship.
Okay then. जी कोई जो due to some due to for the positive time, the matter could not be high. And considering the submission made by learned counsel for the applicant as well as the
Okay.
learned additional PP, let the matter be accordingly listed on third week of June as on a date to be fixed by the registry. Okay, then third week.
Deployed.
All right. Okay. What had happened, in fact, there are some matters I have to dictate in the chamber also. We cannot carry again these records to Guwahati. It will be again create problems, so we have to close it. On Wednesday also, that's why I didn't fix the matter, because Wednesday also 3 matters have already been fixed for hearing. So that is the reason. Tomorrow is a division bench, I think.